Oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, counsel. We're happy to hear argument in our first case. Ms. Soderall, do I have that right?
Good morning, Your Honor. It's Erica Soderdahl, and I'm here on behalf of the appellant, Robert Christopher Sisson. May it please the court. When Mr. Sisson purchased a firearm using counterfeit currency, he did not use or possess that firearm in connection with any other felony offense. Therefore, the district court erred in applying the 4-level enhancement under the United States Sentencing Guidelines, Section 2K 2.1 B6B in this case. We're asking this court to vacate the determination that this guideline enhancement applied and remand this case to the district court for resentencing.
Wasn't his purpose in receiving the pistol to exchange his counterfeit money for a good, like
Your Honor,
good?
Yes, Your Honor, that is one of the government's arguments as to how Mr. Sisson's possession of the firearm was connected to his counterfeit currency offense. However, there's no evidence on the record to suggest that the reason that he arranged for the purchase of the firearm in this case was to pass counterfeit currency. So no, I don't think that the evidence would suggest that that was the reason for his purchase of the firearm.
But that's what he used to purchase the firearm with, correct?
That is correct, Your Honor. He used counterfeit currency in exchange for which he received a firearm. But I would submit that the fact that the firearm was exchanged for counterfeit currency, the mere exchange of these items would not be sufficient to support the application of this enhancement. And that would be based on the language of the enhancement under the guidelines and the commentary, and of course, the purpose for the enhancement as set forth in this case in the Blount opinion. Guidelines.
I thought it was pretty clear that if you traded things, like if you traded drugs for a gun, that you would be, so why wouldn't that translate here? Instead of trading guns for drugs, he translated. And would you claim that if he had been the person that owned the drugs and got the gun for it, that there was no liability under the statute? Would you say it's still there, that there were not two crimes?
Well, it's difficult to answer that question because the facts are so different, and that would be...
Well, the only fact that's different is that we've substituted in drugs for a counterfeit currency.
However, in the counterfeit currency offense, Mr. Sisson was charged in count 2 of the indictment with uttering counterfeit currency in violation of 18 U.S.C. 472. It is not an element of that offense that anything be received in exchange for the counterfeit currency, or in fact, that anything go beyond the mere offering of the counterfeit currency. Therefore, in this case, where Mr. Sisson used counterfeit currency to purchase the firearm, his offense of passing counterfeit currency was complete before he came into possession of that firearm, versus the fact scenario that you've offered, which is the exchange of drugs for guns. In this court and others, they have found that that could be in connection with the possession of a firearm because the firearm is in furtherance of, under the 924C language, or in connection with or facilitated the distribution of drugs. The distribution of drugs has as an element that the drugs are actually distributed, that they actually change hands. It would be kind of like the offense of theft, where a person steals a firearm. One of the elements of theft is an actual taking. So the transfer of the possession of the firearm becomes a part and parcel of the offense.
Right.
It is the firearm
What do the
itself.
elements of the separate crimes, the firearm and the counterfeiting, what's that have to do with the enhancement?
Well, Your Honor, I think that the reasoning that this court and others have held in upholding the application of this enhancement in cases of drug distribution or theft is that it is an element of the offense that the firearm change hands or that the drugs change hands, that the actual distribution is what's furthered or facilitated by the possession of the firearm. Whereas in this case, the firearm was not in furtherance of, or it did not facilitate, I should say, the passing of the counterfeit currency, which was complete at the time that Mr. Sisson came into possession of the firearm. And
You're
that
not,
is,
you're just not suggesting that without the guns, there wouldn't have been a transfer without the counterfeit currency, there wouldn't have been a transfer of the guns.
no, Your Honor, I don't believe that this gentleman who sold Mr. Sisson the firearm would have given it to him without an exchange of some currency.
Yeah.
Now, Your Honor, I submit that the determination of whether the guideline enhancement under 2K 2.1B6B applies is a very fact-specific inquiry that could turn on the factual nuances of each case. And in this case, the record is bereft of facts that would support the enhancement. The government simply did not prove that the firearm possessed by Mr. Sisson after he had completed the counterfeit currency offense was in furtherance of that counterfeit currency offense. In the facts that we have them, the government could have called a witness. In this case, it would have been the person who gave Mr. Sisson the firearm. And they could have had that witness testify at the sentencing hearing to facts that would support the enhancement, to prove their theory that the enhancement applied. But here, in this case, the only facts in the record that were presented to the district court were those contained in the pre-sentence investigation report, which is at the joint appendix, page 55. The government's making arguments in support of the application of this enhancement that are not supported by this factual record. Again, the government's, I think, main argument, at least in its briefs, is that Mr. Sisson possessed this firearm in furtherance of, to protect him or to embolden him to commit this offense of passing counterfeit currency. But the facts do not support this contention. The facts that were presented was that Mr. Sisson purchased an unloaded firearm. There's no direct or circumstantial evidence that Mr. Sisson used it to protect or embolden him to act. There's no proof that he kept it close at hand after he had received it and the transaction was complete. There's no proof that he used the firearm in a threatening or intimidating way. There's no proof of any confrontation or any risk of confrontation between the seller of the firearm and Mr. Sisson, and no proof that Mr. Sisson was engaged in any kind of ongoing counterfeit currency operation for which he might want to arm himself to protect that operation.
Is there any proof that he knew the gun was unloaded?
Well, there's no proof that the firearm, I don't think there's proof.
So there's nothing either way, you know?
Correct. There's no fact either way, Your Honor. That's correct. The only fact that we know is that he purchased a firearm. There's nothing about him purchasing ammunition or otherwise having access to ammunition at the time of this transaction. So all we know is that Mr. Sisson possessed an unloaded firearm. Now, the purpose of the 4-level enhancement to an offense level in cases involving firearms is to more greatly punish an individual whose felony offense is rendered more dangerous by the presence of the firearm, as this court noted in the Blount opinion, finding that there's an increased risk of violence when firearms are used or possessed in connection with another felony. But that purpose is not further.
Blount distinguishable at the beginning because, and as I remember those facts, you have a burglary and then you have the larceny of a firearm. Well, the burglary will have taken place regardless of what the ensuing larceny was, whether he stole the firearm or something else. But in this case, I'm having difficulty understanding how you have the firearm offense without having the counterfeit money offense and vice versa. It seems very different from Blount.
You're correct, Your Honor. I don't think that there's a way to kind of divide up this transaction and have the passing of counterfeit currency separate from Mr. Sisson's receipt of the firearm. But I would submit that the mere fact that the two items were exchanged does not prove the facilitation requirement of the guideline enhancement. The mere fact that a firearm is present when another offense occurs is not sufficient to support the application of the enhancement. The government has the burden to prove that Mr. Sisson's possession of the firearm facilitated in some way the other offense, which is the passing of counterfeit currency. But I would submit that it could have been any object that he would have purchased. That one of the arguments is that Mr. Sisson's purchase of the firearm facilitated the passing of counterfeit currency as if it were the purpose of the transaction. But again, I would submit that that would turn the application of this 2K 2.1B6 guidelines on its head. That would imply that the purchase of the firearm, that the passing of counterfeit currency facilitated, or that the purchase of the firearm facilitated the passing of counterfeit currency, not the other way around. It's not whether the counterfeit currency facilitated, not whether the purchase of the firearm facilitated the passing of the counterfeit currency, but whether the possession of the firearm facilitated that passing.
Well, these cases are indeed very facts specific, and perhaps what guides us here most is in fact the guidelines and the purpose of the guidelines. And this is an interesting case. It really presents a very close question, but when you look at the Smith case, the purpose at least of the gun was to facilitate the drug trafficking. In this instance, you have counterfeit money that in effect, I guess, facilitates the purchase of the gun. The counterfeit money could have been used to buy anything. And so that makes it somewhat more tenuous. And I guess your argument, when you go back, when you stick with talking about what the guidelines intended, and that is that the gun itself made the situation a more dangerous situation, it does put this case perhaps in a different posture than Smith and Blunt. But, the burglary itself, at least in terms of the guidelines, it's tied to burglary. And I don't know if that's a specific type of crime that would differentiate this from something else, but to be able to use counterfeit money and go in and buy a gun, and then the gun itself becomes an enhancement because you purchased it. And I know the government will argue that he could have turned the gun around and maybe used it on him to keep his counterfeit money if the owner questioned, I guess. But I agree. It doesn't make sense. And all the times I've seen people purchase guns, they don't purchase a loaded one, but I guess you could. And I don't know how that works, but it's a close case. But I think it's guideline, the guidance has to come from the guidelines.
Your Honor, I agree, and I appreciate that the government's comment, the government's argument has been that Mr. Sisson could have turned around and used the firearm as a weapon against the seller of the firearm if the seller had learned that the currency was counterfeit. But I think that is that argument is ruined by the fact that this firearm is unarmed and the seller unloaded, and the seller would know it's unloaded. Therefore, it makes the firearm, although technically Mr. Sisson is armed, he's armed with a weapon that is... Does it have to be
a firearm that is loaded? I mean, could it be used in a manner as a blunt instrument or something like that?
It could be, Your Honor, but that... I'm sorry?
Go ahead.
It could be, but it makes it no more dangerous that it's a firearm than it's any other object. It could be a stapler for that matter, because the seller himself knows that it's not loaded. So the seller is not unduly threatened by the presence of this object that does not have bullets in it. And Your Honor...
Who has the burden of showing that the gun is dangerous? In other words, that it is loaded? Is it presumed that a gun is loaded, or is it something that at least the government has to show, at least through maybe testimony of owner or somebody, that this gun in fact was on it, or that it was the usual practice to load a gun and hand it to someone who would come in and purchase it with cash, I guess, bad cash.
In the application of enhancement, the burden rests on the government to prove sufficient facts to support the enhancement. And in this case, the government did not submit the facts that would support the enhancement. Your Honor also mentioned the offense of burglary. And as we all know, after Blount, the application note 14B was added. And although it does not apply in the circumstances of this case, I believe that the language of 14B, the application note, is instructive. The Sentencing Commission could have included any number of offenses and singled them out for special attention, as it did in 14B.
You got about a minute. You're at a minute. I think we're all probably interested in what are you going to do about that language where the trial judge says, well, even if this is not good law, I believe I would do something different.
Well, Your Honor is correct.
In other words, I would do the same thing if I wasn't using that stuff. I meant to say.
In this case, the court did recite what I refer to as the standard mechanical language of, even if I've calculated the guidelines incorrectly, I still would have imposed the same sentence. I would note that in this case, the judge said, I believe I would have imposed the same sentence, which I think is hedging language. But I would submit that this language alone is not sufficient to
Is that
justify
hedging language used in other cases of this sort? I mean, the other cases that I've looked at tends to be a little bit more specific, but does that make a difference? The judge says, I believe I would do it?
I think it does, Your Honor. The judge is not herself certain that she would do it, and she did not in her language say anything about an upward variance.
Can I ask you along that, excuse me, before you go, this is my time, not yours, because your time has expired, just going along that same query, do you make any claim or do you make any suggestion to us that our doctrine about assumed error harmless is incorrect?
No, Your Honor, I would agree that we could
You think that's a good doctrine?
Yes, Your Honor, I do. I just would submit that in this case, we would not get past the first prong of that analysis because we do not have the certainty that the court would have imposed the same sentence. Your Honor, the court was pleased and satisfied with imposing a within guideline sentence for Mr. Cizon. She then used this language that even if the guideline calculation were incorrect, she would have imposed the same sentence, but gives no explanation in her reasoning why she would have imposed an upward variant sentence. If
I think I understand your argument. You're over time now. You have some rebuttal time. Thank you.
Thank you, Your Honor.
Mr. Garner?
Thank you, and may it please the court. My name is Ben Garner, and I represent the United States. This court should affirm Mr. Sisson's sentence because the district court reasonably inferred that Mr. Sisson possessed a firearm in connection with the passing of $400 in counterfeit currency and correctly applied the 4-level enhancement under Section 2K 2.1 B6B. Alternatively,
what is the case that you have found that is factually closest to this one? Because I agree with Judge Wynn. This seems like an odd bird. That's my language, not Judge Wynn's. A close case.
And Judge Motz, I have scoured Westlaw to find a case that is factually on point, and I have not found one that is directly on point. However, I have found several that I believe support the fact that the enhancement should apply in this case. The case law is rather clear insofar as that it is a fact-specific inquiry to make a determination as to whether or not the firearm was connected to the other felony offense or whether it facilitated or had the potential to facilitate. And what this court has time and again looked at are such factors as to whether or not the firearm was possessed in the dwelling of the defendant, which would weigh against the connection prong of the guidelines insofar as that firearms are routinely kept in the dwelling. In this case, the transaction took place in the public and at night. Both of those factors weigh in favor of showing that the firearm was actually connected to the other felony offense, in this case, the passing of the
well, it's clearly connected. I mean, if we had to, it's clearly correct that the false money, the counterfeit money, was that if we had the reverse case, if you got an extra sentence because of the false money, you wouldn't have any problem. But that's really not what you have. I mean, the defendant here used the false money. And that was the object of what he got. There's no doubt about that.
Absolutely.
It's harder kind of putting it the other way.
Right.
And that's what I was asking about. Not being very articulate. Sorry.
No, I apologize. I misinterpreted the question. And I think in this unique case, the best way to analyze the facts are not to compartmentalize the passing of the counterfeit money as well as the acquisition of the firearm. To the contrary, it was the same course or conduct. It was a singular transaction that took place simultaneously. And it's the government's position that that the possession of the firearm, or it's at least a reasonable inference from which the court could draw that the possession of the firearm either emboldened the defendant and also protected the defendant during the course of the transaction. The facts set forth in the pre-sentence investigation report, which were the offense conduct was not objected to and formed the basis of the facts that the government argued in support of the enhancement. And as I indicated,
Where was this gun? Was it from a dealer? Was this seller a dealer? I seem to forget.
I don't believe there's any indication as to whether or not the seller was a licensed dealer. The information in the record notes that he had marketed the firearm on a social media app, and the defendant, Mr. Sisson, used a fictitious name to orchestrate the purchase of the firearm.
And you say that once he sold the gun and the defendant had it, it emboldened the defendant at that point.
Yes, Your Honor, absolutely. And insofar as at that point, the defendant.
And how would it embolden him? Is there evidence that the gun was loaded?
Your Honor, there's two places in the record that at least create an inference that the firearm was loaded. The first is in Joint Appendix 13, that is the indictment, which charged Mr. Sisson with possessing both a firearm and ammunition on October 8th, 2016. Furthermore, paragraph 23 of the pre-sentence.
Is that wouldn't be enough? So I guess the next paragraph is going to say because you just got ammunition and gun, and then the next paragraph says what?
Your Honor, I was just going to the next paragraph. There's going to be the next paragraph of the pre-sentence investigation report, which is paragraph 23. Also, it was not objected to, and it notes that the ATF agent examined the firearm and ammunition that Mr. Sisson purchased on October 8th, 2016. So there's at least some support in the joint appendix that the firearm was indeed loaded on October 8th.
But what you're missing, at least what I'm not hearing, is the temporalness element here. That is, that it was loaded at the time of this, that he was purchasing it.
I think it at least creates an inference that the transaction took place, the offense conduct took place on October 8th, 2016. There's no other evidence that I'm aware of Mr. Sisson.
So let me lead you where I think. Well, let me ask you, because this is the concern of mine. If you have a dealer, basically what you're saying is a dealer, or any firearm dealer, because by virtue of the fact they're selling firearms and ammunition. The mere fact, well, not the mere fact, the fact that anyone goes in there and commits a felony of any type, by definition, they will have this enhancement applied to their felony. That is going to happen just because you purchased a gun or you acquired a gun from a gun shop. So you could actually walk in under this. It sounds like to me, you could come in and you might not even purchase one. You might do something that's a felony, and you pick up one of those guns because you're kind of looking at it. Then you got the enhancement. That's going to happen too. Even the felony has no connection to it, or even maybe it does. But I'm trying to understand. It just seems to me it creates that environment of a gun dealer or someone who's selling guns. The gun is part of what the business is. The gun is inherent in what they're doing in the transaction. Not like a drug trafficking. It might seem like it's inherent, it's not necessarily. But in a gun shop or gun sale, there's a gun involved. That's already involved. And the question here is, he didn't bring the gun in. The gun is already there with the so-called victim here in this case, and it's not used to facilitate the counterfeit money, because he brings the counterfeit money in, gives it to him, and once he gives the counterfeit money, isn't the crime complete at that time of counterfeit exchange? Even if the gun is not handed to him right then. You have to show the gun is being handed to him right then. But once he gave the counterfeit money to him, then it seems like to me, when you say emboldening, you're talking about trying to get your money back. That's a different crime, isn't it?
Judge Wayne, a couple of responses to the question. In terms of the distinction between whether the firearm is sold from a licensed dealer at established business, as opposed to the facts that happened here, I think that's a distinction that certainly matters. And it's certainly a limiting principle in the government's position before the court.
I only bring it up because it seems to be applicable. If we rule in this matter, it will apply to that situation. That's all. It doesn't have to, whether he's licensed or unlicensed, but someone who's in the business of selling guns or selling guns has the gun. And then so when he walks in and he hands the counterfeit money to him, usually people don't, I don't know, maybe he did. Maybe there's evidence he gave him the gun first, he examined and took it and then gave the money back. I don't know. Maybe that matters or not. But if you hand the money and then they give you the gun, which probably if I was selling a gun as a seller, I wouldn't give you my gun before before I got the money. But I'm just thinking, how does that work? Does that matter? I mean, it seems to me it matters. If the crime is counterfeit money, handing it to him and receiving, you've committed the crime then. That crime's complete. Once you then, the emboldened part of it of trying to get it back seems to me to be another thing.
And Judge Wayne, I think this certainly would be a different case. Say, for example, to the extent there was a temporal difference between when the counterfeit money was provided to the seller and when the defendant obtained the firearm. That's not the facts here. The facts here are that Mr. Sisson provided the seller the counterfeit money and in return immediately received the firearm.
Well, I don't understand, excuse me, I don't understand how it's different at all. Let's take Judge Wynn's example. You have already talked to these people at the shop and you ascertained that they have the kind of gun that you want. So you bring in your counterfeit money, you give the counterfeit money to them and they give you back the gun. Same situation as we have here, right?
But Judge Mons, I think you have to look at the risks associated with the transaction that took place here. And the risks are insofar as that this was not a licensed drug dealer. There's nothing on the record to support it was a licensed drug dealer. This was an informal transaction in which Mr. Sisson used a fictitious name, duped the seller into exchanging the firearm for the counterfeit currency.
The duping is not any different than it is in Judge Wynn's example. I mean, he doesn't come in and say, this is counterfeit money that I'm going to pay for the gun. The purchase is with the same counterfeit money. I think that we're getting pretty far away by adding extra elements. Suppose we take Judge Wynn's example and we have not a licensed gun dealer, but somebody on the street who sells guns, and everybody knows he sells guns. And our guy wants a gun, and he comes in and he says, okay, here's $500, whatever. Gives him the $500 and he gets the gun. Is it covered by this? How is that any different than the licensed gun dealer? The license isn't part of the statutory definition.
It's not, but I would submit it is a factor that this court can consider in analyzing whether or not the firearm actually emboldens the defendant here. It was a transaction that took place very informally via social media, in which case the individuals were Mr. Sisson and Mr. Sisson and the seller were complete strangers. The transaction took place in a parking lot of a gas station at night. And so I think that certainly intensifies the risks associated with the proposed transaction insofar as that.
You gotta believe that someone who goes in a docking spot to sell a gun at night, inherently within that, they understand if you hand a gun over to someone with ammunition and get money back, you put yourself in that position. And I'm not saying that wouldn't keep the element from being emboldenment. The problem here is, again, the crime is counterfeit money exchange, I guess. He's completed it under this scenario. So then the next thing that happens is he's got it in his hand. The gun, for all purposes, is presumed to be lawfully possessed. We have gun laws that are all over the place, but that's pretty strong. Once you get a gun, you can have a gun in this country. There's no question about it. And once he gets the gun, then you say the fact that he now has a gun, presumably lawful, but not lawful because we later found out it's counterfeit, that's enough to say that the fact that he has already given counterfeit money to enhance that crime. That, you see where I'm going? If you keep this up, if we keep this up, it's the gun laws that is really being affected here, because the possession of that gun, it carries to other instances. The possession of a gun, however you got it, and even after something has occurred, can be a problem.
And Judge Wynn, I can certainly anticipate that there would be certain line drawing issues with application of this enhancement as it applies to licensed gun dealers. I think it's also important to note that in this case, and with the seller, even though the seller did agree to the arrangement, did agree to the location, with the seller, there's no evidence to support the fact that the seller expected that Mr. Sisson would pay for the firearm $400.
let me ask you, what difference does it make whether or not the person who acquires the firearm is emboldened after he acquires it? I mean, don't the guideline specifications apply to the transaction that occurred before that? What difference does whether or not he's emboldened or not make?
And it's not the government's position that Mr. Sisson was only emboldened after he possessed or after he acquired the firearm. It's the government's position that the entire transaction, the other felony offense in this case, the passing of the counterfeit money, that he was emboldened with under the prospect that he would actually obtain the firearm. So the passing, so that's actually what emboldened.
Well, are you saying, is it the government's position that they have to prove this emboldenment in order for the enhancement to apply?
No, Your Honor, that is certainly one way that this court has indicated to satisfy whether or not the firearm has the purpose or effect of, has some purpose or effect on the other felony offense, or alternatively, facilitates or has the potential to facilitate the other offense. And that was the theory under which the government proceeded, or one of the theories under which the government proceeded below, and one of the theories under which the government is proceeding on appeal. I would note that this court has indicated that a district court is free to draw common sense inferences from the evidence to determine whether or not there was a logical connection or nexus between the firearm and the other felony offense. I think taking into consideration all of the facts and the circumstances given this case, the fact that it was a single transaction, same course or conduct, the transaction took place at night in public as opposed to the defendant's own home or dwelling, and the fact that the defendant essentially stole the firearm from the from the victim, all support a common sense inference that the firearm either emboldened Mr. Sisson or alternatively protected him while engaging in the other felony offense of passing money.
What did it embolden him to do? You said embolden him to do what? To not take the money back?
It emboldened him to pass the counterfeit money in the first place in order that
I thought you said he did that before he even got the gun.
What I indicated was that part of the same course or conduct. It was a singular transaction.
I understand that, but think about it in terms of the crime and passing counterfeit money. I mean, you can stretch it as much as you want to. It could be when he walked out of the door, whatever he's doing is still part of the crime. But the fact of the matter is, it's a non-violent crime. It's a crime of money. You're handing someone what appears to be real money. The person getting it thinks it's real money. He doesn't complain at that time. It's later on. So there's no. I mean, as I understand it, it's later on. He didn't try to contact him on Facebook to get the money back. He didn't. The person that got the money thought he had money. So everything you got here, there's no reason to be emboldened by someone who thinks they have good money. You can walk out and go do what you're gonna do.
And Judge Wynn, it is fortunate that the seller did not immediately discover that the money that Mr. Sisson provided him,
that's my point. That's my point with the emboldened or any other part of the transaction is, you're giving the counterfeit money is given, and he goes out. And then you say he's emboldened, and later on he contacts him. It could have been a year later. He contacted him and says, wait a minute, I've been keeping this money up in the corner, and I found out now it's counterfeit. And by the way, the court says, oh, you bought a gun with this? Enhancement. Even though neither one of them even thought about the fact, because that's what counterfeit money is. It's not play money in terms of you look at it, the average person can look at it and do it. Usually it's money that can fool people to think you actually have money. So he thinks he has the money. He goes out. He thinks he's, as you say, duped him into taking it for getting this gun for his money. And I don't get the connection. I don't get the connection with the gun emboldenment or transaction or anything else here, because this gun is not used, as in Smith, to facilitate the purchase of drugs or the purchase of the gun. If he walked in with a gun and says, I'm going to give you this counterfeit money, give me a gun, I got it.
And Judge Wynn, pursuant to the application notes of this guideline, it doesn't have to facilitate the other felony offense. It can also have the potential to facilitate. And you are correct that, fortunately, in this case, the seller did not immediately discover that the money was counterfeit. But Mr. Sisson did not know that when he engaged in the other felony offense of passing the counterfeit money. He engaged in a risk by essentially having the effect of stealing the firearm from the seller. So, fortunately, and so it's the government's position that even if this court were to conclude that it didn't directly facilitate, it certainly had the potential to facilitate, and that is sufficient under the guidelines as well as this court's application and interpretation of the guidelines.
In other words, you can purchase the means to facilitate the crime. And that's what he did here. He basically sought to purchase a means from the victim. He purchased from the victim a way to commit the crime.
Well, he acquired from the victim. He didn't pay in genuine money, but he did, in effect, steal.
Audience thought at the time of the transaction, but I don't think it matters whether he acquired it, but he acquired it with the consent of the victim at the time. The victim comes in and hands him a gun, and he hands him money. And then you say, well, this criminal has now committed an enhancement situation because the victim handed him the means to embolden him to facilitate this crime.
But there was no guarantee in Mr. Sisson's mind that he would be successful in the exchange of the counterfeit currency and the acquisition of the firearm. There was a true risk here.
You see where I'm going? I get you, and I feel where you're going on it. But see, you just said no guarantee in his mind. Now, who knows that? I don't know what a person who I can't even imagine having the nerve to walk in and hand someone the counterfeit money for a gun in the first instance. I mean, the person with the gun looks like to me, it might not be happy with the fact I bring him a counterfeit money. He's the one that's got the gun. And then I'm trying to get it from him for counterfeit money. That's dangerous. But I get your point.
And that's exactly why it emboldened the defendant. And so I see that I am out of time for all those reasons and the reasons set forth.
I have one question that we haven't touched on, and that is this business about the imposition of sanctions. A late-breaking development?
I'm sorry?
I'm sorry, not conditions of supervised release. Remember you wrote a letter about that? They wrote a letter?
Yes, Your Honor. And with respect to the Rogers error claim, counsel for Mr. Sisson did provide to the court less than 2 days before oral argument a 28J letter setting forth claims of an alleged or two alleged Rogers error based upon the district court's oral pronouncement of the sentence, including the conditions of supervision is the government's position pursuant to this court's case law with Alford and Leeson, which are cited in the government's response to the 28J letter.
See, the problem with that is that the cases upon which the defendant relies on here were decided after the briefing in this case. And the cases upon, sorry?
I certainly don't dispute that, Judge Mine. I did not mean to interrupt you.
No, okay. And the case that you rely on, that's not the case. The precedent that you rely on is not the case. It wasn't decided after briefing.
Yes, Your Honor. However, it's the government's...
And does that make a difference?
Well, the government's position, Judge Mott, certainly would have been different if appellant's counsel had reached out to the government and asked to move to supplement briefing on this case. The primary authority upon which Mr. Sisson relies in the 28J letter is United States versus Rogers, which is nearly 2 years old. This case has been pending for 3 years and
but the two underlying cases, United States versus Rogers and Singletary, were both took place after the briefing here, right?
No doubt about that. Yes, Your Honor.
Okay, so you knew about them too, right? I mean, I'm not saying that they weren't late, but I've looked for a precedent that does what you tell us we should do, which is ignore them. This is because it's late breaking. And frankly, it's not a good thing that it's late breaking. But it strikes me that maybe this is an open question. Maybe we should get briefing on it.
And that's precisely what the government wanted in terms of developing the claims, what actually took place before the district court. The government did cite in its response to the Rule 28J letter, United States versus Thompson, which is, albeit a case from the Eighth Circuit, And in that case, the court refused to consider an argument raised for the first time in a 28J letter, even when that argument relied upon circuit court precedent.
Yes, but I've tracked those Eighth Circuit cases, and there are a bunch of them. They're very convinced about this, but there's not a lot of authority anywhere else. I couldn't find it. You haven't cited it. They haven't cited it.
No, Your Honor. And the government's position is that it just wanted the opportunity to fully brief the issue rather than attempts to address it in a Rule 28J letter where each party is confined.
Well, what if we gave you each an opportunity to brief the issue?
The government would have absolutely no opposition
All right.
to that.
All right. Thank you.
Thank you.
Kept you over your time. Do you have rebuttal? Ms. Sutterall, do you have rebuttal?
Yes, Your Honor, I do. First, I wanted to respond to some of the questions that were asked of Mr. Garner regarding the presence of ammunition and whether the firearm was loaded. And just in case that's not a resolved question, I would note that the indictment does allege on or about October 8th that Mr. Sisson possessed both the firearm and ammunition. But the facts that are set forth in the pre-sentence investigation report on which the government rested in this case suggest that Mr. Sisson was, the police went to his residence and found under his bed a firearm and ammunition 2 days after the transaction. So he was charged with the firearm and ammunition. They were found together, but not at the time of this transaction. And there's no evidence to suggest that the firearm was loaded at the time of the transaction. And so again, I would just note that the government has the burden of proving that the enhancement applies, and the facts and circumstances that were presented in this case do not meet that burden. I would also like to respond to Your Honor's concerns about the late filing of the 28J letter, and I do apologize to the court for this late filing of supplemental authorities, and apologize. I regret that I did not catch the issue sooner. However, as soon as it came to my attention as I was preparing for this oral argument, I felt compelled to raise the issue to preserve my client's rights, and also knowing that this court has been committed to correcting these errors on appeal, to remanding the cases for resentencing so that the error can be corrected. In fact, just yesterday, an opinion was released by this court, United States versus Isidro Cruz, case number 21-4065, in which another, it was an Anders brief, and this court, upon review of the record, learned of the error and did remand it. Regarding the cases cited in the government's response to the 28J letter, especially specifically about the Thompson case, the facts of that case are, as Your Honor pointed out, distinguishable because the person who was filing the 28J letter sought to add a Supreme Court opinion that had been decided before the briefing on that case. And then
not all of the Eighth Circuit cases are that. Some of them are closer to the situation we have in hand. Facts are.
In Thompson, the 28J letter was filed after oral argument, despite the fact that the opinion had been issued before. And the court in that case, in finding that it would not consider the issue, said that this Rule 28J is not a vehicle for parties to say what they could and should have argued in their briefs. And that's what distinguishes it from this case. These cases had not been issued at the time that the briefs were filed in this case.
So, but did you track down the other Eighth Circuit cases? There is Eighth Circuit authority that is in the same posture as this case.
No, Your Honor, I did not. I just read the Thompson.
That's okay.
So why did you wait so long?
Your Honor, I am a little bit new to the case. I was reviewing it with fresh eyes, and I was focused as I reviewed the case on the issue before the court. So I focused my attention on the facts submitted in the record, the parties' briefs, the sentencing record regarding what facts the court considered, and did not, I admit, did not focus my attention on the court's imposition of the supervised release violations.
Right,
or the
but
supervised
your
release.
office has represented Mr. Sisson for over 2 years.
Yes, Your Honor, the case was held in abeyance for quite some time. That's correct.
Would this have any practical? Sorry.
No, I'll just be very frank. It bothers me significantly that counsel can represent a client for such a long period of time and then file 2 days before an oral argument. That's just not good practice.
I do not dispute that, Your Honor, and I do apologize for that. I did feel it necessary to file something with the court to bring this issue to the court's attention as soon as I learned of it. I knew that it would be frowned upon, but I didn't see any other way to bring it to the court's attention. My apologies for that. I also wanted to
Can I just pursue this just a minute? Does this have any practical effect on your client? I mean, is he about to be released? Only you know the facts here.
Yes, Your Honor, Mr. Sisson is currently still serving the active sentence in this case. He tells me that he has received a release date of sometime in April of this year. He was released to a halfway house, is currently residing in a house on electronic monitoring, but his supervised release will begin in April. Despite the fact that he's no longer in prison, his liberty is still restricted by those supervised release conditions. So the issue is not moot.
So I thought one of the issues was that there was some discrepancy on where he was supposed to report to the probation officer. So if he's out, he's already done that, correct?
I see that I'm over my time. May I respond to your question?
Yes.
Yes, Your Honor, Mr. Sisson has not yet been required to report. It's my understanding, based on the government's filing yesterday, that his probation officer that has been assigned to supervise him on release has contacted him and let him know where and when to report, but it's my understanding that he will not actually report until April. It may resolve, and I don't know that it does, but it may resolve one of the issues we raised in our 48J letter, but not the issue of the conditions that were imposed that were not, that Mr. Sisson was not given instruction of in the sentencing pronouncement. Thank you.
Thank you. My colleagues, are we ready to go on to the next case? Yes. All right, we'll go on to the next case.
Your video.
Counsel, we're glad to have you with us. We're hearing argument in number 20, 2382, 21, 1061, Cannon versus Peck. Mr. Blanchard?
Good morning, Your Honors, and may it please the court. My name is Norwood Blanchard, and I am here representing the Village of Bald Head Island, Calvin Peck and Caroline Mitchell. Mr. Peck and Dr. Mitchell are appellants in this matter, and the village is I suppose you'd call them a crossbelly.
What?
The
village is a
there has been a cross. Yes, a cross-appellee.
Appellee. I said
yes,
cross belly. Go ahead.
I apologize, Your Honor. I'm using my son's gaming headset here today. So, Your Honor, this case is
Mr. Blanchard. Let me ask you at the beginning. I was a little confused in the briefing, but has the village conceded the liability and damages to Mr. Terrell and Mr. Coons?
The village, Your Honor, has already satisfied the judgment that was entered against it. Or I'm sorry, nothing was. The village was found not liable on any of the claims at trial. So there's nothing for them to concede.
Well, Mr. Peck or whoever is the payee here, are they conceding the issues of liability and damages as far as Terrell and Coons are concerned? That would seem to be a fairly important threshold question.
With respect to Coons and Terrell, the only issue we're raising is the libel per se claims on the termination letters. And there were two separate claims here for defamation. One of them was the termination letters, and the other one was the Form F5s. And what the trial court found was that Peck was responsible for the termination letters, but not the F5s, and that Mitchell was responsible for the F5 forms, but not the termination letters. So Mr. Peck is.
So you're contesting Mr. Peck's liability to Terrell and Coons as well as the other plaintiffs.
To Coons, yes, with respect to their termination letters, yes, Your Honor.
Okay.
And that is in our opening brief at pages 26 to 33. And I apologize too. The first issue we had raised was with respect to Plaintiff Connor. The trial court ruled that Plaintiff Connor's libel claim was a libel per quad claim. And the issue that we raised on that, we raised this by way of a motion for partial findings at trial, at the close of the evidence, again at trial, in our proposed findings, and now for you. But the problem that we had with Mr. Connor's libel per quad claim is that under North Carolina law, libel quad requires the claimant to show that he has incurred special damages prior to the filing of the lawsuit. As we pointed out in our briefs, North Carolina law determines what evidence must be offered to establish liability for a state law claim. Under these circumstances and under the facts that were found by the trial court, Connor simply failed to offer any evidence of special damages that he had incurred prior to the filing of the lawsuit. Again, we pointed that out. The plaintiffs conceded that Talent versus Blake, the primary case that we cited for that, because it's the best example, has conceded that that is, in fact, the law, and North Carolina does require that. Under these facts, Mr. Connor simply hasn't shown that. Now, the effect of that, Your Honor, would be that Mr. Connor, if he has not shown any special damages, then he can't receive the $1 in special damages and can't receive the other presumed damages that were awarded, nor can he receive punitive damages for that claim without the underlying liability. So we're not, with respect to him, we are contending that he did not establish liability and that claim, the court should simply reverse on that. Moving on.
And that's on the termination letter as to Cannon, but
Connor.
not the form.
Connor. Yes, that's on the termination letter. Yes, Your Honor. Yes. Now, with respect,
why is the essential issue they're not actual malice? I mean, the question of actual malice in terms of the proof of it.
That we also raised the actual malice issue, Your Honor, and I'm glad that you moved to that. The reason that I pressed the issue on the special damages first with respect to Connor is because there's no dispute about it. When I'm trying to move for judgment as a matter of law, I have to show that there's no factual dispute. Now that one is the easiest one.
I brought it up because you brought up the special damages. It seems to me you don't get there if you don't have actual malice.
And agreed,
but
Your
even
Honor,
if you do, then your argument would be special damages would not be proved. So I was interested to know why you did not start with dealing with the question of whether the proof of actual malice, which would invalidate the defamation claim here, would be a problem.
And I put that argument later, Your Honor. Yes, I am making both arguments, but I thought the special damages one was the clearest cut argument we had. As you pointed out, actual malice is an important issue in this case, and it's reviewed de novo under the Bose case. For Mr. Peck,
it's the issue in all of these, in all of the termination letters. It's the issue with regard to the letters of Cannon, Terrell, and Coons, that letter, and the issue with regard to Connor's letter, too.
Yes, Your Honor, and with regard to Mr. Peck and the actual malice test, The argument that we're making with that was that based on the facts that the trial court found that Mr. Peck believed or had been told that there was a complaint. The trial court also found as a fact that Mr. Peck was subjectively, he found those text messages offensive. Now, with respect to actual malice, it's one of those situations where the claimant has to show not that the defendant acted unreasonably, but that subjectively the defendant knew or strongly suspected that what his utterance was, what he says was false. And with respect to Mr. Peck, if he believed that there had in fact been a complaint, which is what the district court found, and he himself found the text message exchange offensive, and we pointed out that the district court also found that at least one other member of management, Anderson, found it offensive. In light of those facts, those underlying facts, the legal issue of whether actual malice could be shown with respect to Mr. Peck, we believe that it certainly could not by clear and convincing evidence. Clear and convincing proof here would require basically all of the evidence to point in one direction and there not to be any evidence in the other. And in this case, that threshold was not met.
So does it make a difference in the determination of actual malice whether it's a libel per se or libel per quad?
The difference between, and no, not on actual malice on that. The difference between libel per se and libel per quad, the reason we're focusing on that is libel per quad has this special requirement that you have to show special damages and that you incurred the special damages before you file the lawsuit. So it's kind of an extra step for the libel per quad. You don't get anywhere on libel per quad just by showing damage to your reputation. You have to show a monetary loss. And a monetary loss, importantly, that occurred prior to the time you filed the lawsuit. And that's what Mr. Connor failed to show here. And again, we clearly raised the issue 3 times prior to us coming to the Fourth Circuit on it. With respect to Mr. Peck, though, and the termination letters, we had argued that they should have been classified as libel per quad instead of libel per se, because you actually had to look at, and that same thing is true with the F5 forms, you have to look at the underlying village policies and the definitions contained in them to determine whether or not the statements are libelous. And under North Carolina law, to be libel per se.
Are you talking about both the termination letters and the forms now?
With respect to the termination letters for Cannon, Coons, and Terrell, and all of the F5 forms, that's what we're saying. Yes, Judge Agee, that's correct.
Well, the forms all contain a statement by Mitchell, not by Peck, that there was a complaint filed, and I'm not finding any evidence in the record that shows that that's true and that would appear to be false on its face. And my understanding of the district court's opinion was that it looked to the policies not for the general proposition of examining the statement on its face, but whether or not there was falsity to the statement, and concluded that when you looked at that the village policies, that the statement had to be false because the facts as alleged did not fit it.
Looking at the village policies, Your Honor, is what takes it out of libel per se and puts it in libel per quad. That's the point we're making. And Your Honor, I would concede the point that you're making, that he found that Carolyn Mitchell's statements were indeed false. But the question of whether it's false and the legal, which is a factual question, whether the person knew it was false or not, and the legal question of whether it was libel per se or libel per quad are different things. We're saying that it falls on the liable per quad side of the fence because you have to look at those village policies to determine what conduct they're accused of engaging in.
Is this why you didn't appeal the holding that Mitchell acted with actual malice in filling out the form?
Yes, Your Honor. It was misclassified, but if the judge found that that she knew that that was false, then we didn't have a basis for appealing whether or not actual malice was present. We're just saying it was misclassified as with respect to Mitchell now, that it was misclassified.
But you did appeal the holding that Peck acted with actual malice in
Yes,
signing
Your Honor,
the
we
letters.
did, because factually, based on the facts that the court found, the trial court found, sitting as a finder of fact, Peck was told that there was a, and I apologize, Your Honor, I'm out of time right here. Should I
You can answer the
complete?
question.
Peck was told, and there's no dispute about this, Peck was told that a complaint had been made, and there is absolutely no evidence that he disbelieved that statement. So what the factual finding that we're left with is that Peck's thought bubble over his head was a complaint's been made. A complaint's been made. I found this statement offensive, and I know that other members of management found it offensive. So with those facts, our contention is that you could not have found actual malice on Peck.
Okay. I think you've reserved some time for rebuttal. Everybody seems
Yes.
to be having rebuttal.
Thank you, Your
Okay. Mr. Potter?
Good morning, Your Honors. My name is Samuel Potter. I represent all of the plaintiffs / appellees in this matter. And I want to start where Mr. Mr. Blanchard just left off in your question, Judge Otts. If Mr. Peck's letter, which is the subject matter of this lawsuit, said, "I'm firing you because I read some text messages that I found offensive and other people did also," then we wouldn't be here today. That is not what the alleged defamatory statements are that formed the basis of liability after almost 8 years of litigation. Judge Wynn and Judge Agee should be familiar with this case because they ruled on it back in 2018 after summary judgment. What Mr. Peck's letters say is that our clients harassed people, that they sexually harassed people, and in each and every one of those letters, it stated that the egregious nature of these communications and the flagrant violation of policy thus constitutes detrimental personal conduct and is thereby grounds for immediate termination. Those are the defamatory statements made by Mr. Peck. And Judge Howard found at the end of the trial that those were not the reasons our clients were dismissed from their jobs. They were in fact dismissed because Mr. Peck determined that our clients were jerks. So this whole argument over what Calvin Peck believed or didn't believe about a statement being made, a complaint being made, whether anybody found these text messages offensive or not,
Well,
is not
let
what
me
we're
ask you,
here.
under our standard of review, here the district courts made this factual determination that, based on Mr. Peck's own testimony, fired these folks because they were jerks as opposed to what was in the termination letters. What deference do we give that under our standard of review?
So I believe the case law cited by Mr. Blanchard is correct in that on this issue, it's reviewed de novo. So it's on the Fourth Circuit, it's on Your Honors, looking at the record in the case to review the evidence in the case to decide whether or not we met our burden at trial or not.
Well, so does that mean, to follow up on Judge Agee's question, that if we conclude that calling someone a jerk is just another way of saying these other things, there wouldn't be recovery?
There absolutely would be recovery because—
Well, not if, because we are making a separate determination. According to you, we're looking at it de novo.
You still have to look at the statements that are in the letter. I mean, you have to look at
Right,
it.
and we look at the statements in the letter and we look at I fired them because they're jerks. I don't know that those two things are inconsistent.
I would submit that sexual harassment and calling somebody a jerk are seriously divergent statements.
Well, I think jerk could include sexual harassment.
Right. So,
and sexual harassment could clearly include jerk.
Well, I think that's being too kind to sexual harassers to only call them jerks, but
it could include jerk, not that it was. All right, go ahead.
So moving on, the other thing that I don't want to lose sight of here for the court is that the appellants spend a great deal of time, as they have in the pretrial motions, as they did at trial, drawing out offensive text messages that were exchanged in a 16 to 18 page text message exchange. Crude jokes about anatomy and innuendo about Director Mitchell being a lesbian. What the appellants leave out, and what they left out at every stage of this case, is that none of those text messages that are referenced in the brief that is submitted to you were sent by our clients. There were undoubtedly offensive text messages that were contained within those communications, but they're not text messages that came from our clients. In particular, Mr. Cannon, Tom Cannon, sent one text message and wasn't even on the text message exchanges that contained these jokes and innuendo, number one. And number two, these text messages, all of them, it's undisputed at trial, were sent while our clients were off duty on their personal cell phones. And there was no evidence at trial from any testifying witness that this created any kind of hostile work environment, that any of our clients had anything other than glowing reviews as officers throughout their tenure. And so that all becomes relevant when you look at what were the subjective motivations of Calvin Peck in this case. Mr. Blanchard has spent a great deal of time talking about how Mr. Peck believed that a complaint had been made. Mr. Peck found the text messages that our clients didn't send offensive. He couldn't identify any offensive text messages that our clients did send at trial or in his deposition that was admitted into evidence. And yet he still signed this letter that accused our clients of these things. And after trial, the court found that he just simply was not credible, because not only did he testify his real reason was that they were jerks, but also that there was no evidence to support his conclusions that harassment or sexual harassment or discourteous treatment or any of the things that are in the letter were true, or that he believed them to be true at the time that he made them. So, those things are all evidence of the malice.
Who prepared the termination letters?
There was differing testimony on that, Your Honor. The director of HR at the time, Dr. Ellison, testified that she and Mr. Peck prepared the letters together. Mr. Peck contends that Dr. Ellison prepared the letters, but Mr. Peck never denied that he signed the letters and understood that he was making that communication himself.
So I thought there was testimony from somebody who I thought was the HR director that Mr. Peck delegated to the HR director the preparation, essentially, that the HR director was to look through the village's policy manual and find the bases for firing the plaintiffs. Am I remembering incorrectly?
I believe you're remembering incorrectly, Your Honor. I believe that he pointed out the things that he wanted to include in the letter, and she prepared the letter. Was her testimony. So turning to this issue of special damages as it relates to the per quad claim with Mr. Connor, the appellant focuses and tries to frame our claim for special damages as the damage caused by being fired from the job. And the argument, as I understand it, is because the publication of the defamatory statements were made after the termination, that our damage occurred prior to the defamation and cannot be the basis of a lawsuit arising out of that post-publication. But that is a mischaracterization of what our claim was in this case. We spent a great deal of time with all four of our clients on the stand, but Mr. Connor in particular, noting that his diminished earning capacity was caused by the publication, that he continues 6-7 years after he was terminated, and certainly during the year after he was terminated and before this lawsuit was filed, to have diminished earning capacity. And he testified to that clearly, and Judge Howard found it credible. Now, the other evidence that supports the continued diminished earning capacity are our other three clients. Mr. Coons applied for dozens of jobs and only eventually got a job because he had a personal connection to the chief in the village or in the town of Charlotte in Brunswick County, North Carolina. Mr. Cannon applied for dozens of jobs and was unable to get one at all, other than working as a tree farmer in Western North Carolina. And Mr. Terrell, after trying to find a job, eventually gave up and started doing something else for a living. So the special damages, the pecuniary loss that Mr. Connor suffered was his diminished earning capacity and lost income that occurred after publication of the defamatory statements and prior to the lawsuit. Now, that special damage has continued after the lawsuit was filed, but that's an important distinction here, that we're not just talking about the fact that he lost his job at Bald Head Island. It's the continued effects of the defamatory statement on his ability to get employment elsewhere.
What is the evidence in the record that that his inability to find other work or his TSD disorder, post-traumatic stress disorder, were the result of libel?
So his taking the last of those, the PTSD was what he testified to at trial that he had been diagnosed with. And for purposes of this,
No. I'm sorry. I bet I haven't been clear on my questions. I understand that he testified to that. What evidence is there that the libel caused that?
His testimony. That's all.
Well,
but Your Honor, I would concede the PTSD is not the basis of special damages. That's not, we can move on from that.
All right.
For purposes of this.
The inability to find law enforcement employment, how is that the result of libel?
Because number one, if he applies for a law enforcement job, this F5B would be disclosed to them, stating that he was fired for creating a hostile work environment after a complaint was filed regarding his conduct.
And he showed evidence that would happen?
He testified to that, Your Honor. Now, but moving on from that, Mr. Connor.
Well, wait a minute. I mean, did he testify or present other evidence that he actually applied for a law enforcement job?
He did not, Your Honor. And that was the point I was trying to make earlier, was that, each of our four clients testified that these statements, both in their F5B and the publication of the reasons for their firing, which were false, made it nearly impossible for them to get law enforcement or emergency medical position or firefighter positions. Some of our clients came from a law enforcement background. Some of them came from firefighting and emergency medicine background. Mr. Connor was from the firefighting and emergency services background. And so he was more likely to go that path. The evidence that came out at trial was that the only jobs that any of these four gentlemen were able to obtain after they were dismissed were jobs that came out of close personal connections with the specific people who were managing those organizations. So none of our clients got jobs.
But I think that's not directly responsive to Judge Agee's question. What he asked you was, did they apply to him for any other jobs?
Mr. Connor did not apply for any other jobs. is the reason Mr. Connor did not apply for any other jobs was because he knew, and there was testimony at trial to this, both from Mr. Connor, from our other clients, and from our other witnesses, that this type of statement, this type of thing in your record as a firefighter, as an emergency medical professional, or as a police officer disqualified you from employment. And Mr. Connor knew that. All of our clients knew that. And what's happened to them in the almost 8 years since they were fired demonstrates the difficulty. I mean, Mr. Connor is still getting paid significantly less than he was at the Village of Bald Head. And I would submit to the court that he's not doing that because he thinks he's going to recover money from the Village of Bald Head. He's doing it because he knows that he can't get a job anywhere else. Mr. Coons, for instance, was able to get a job after a year of looking. Mr. Cannon was never able to get a job, ever. And these guys know each other. They know what the other is going through. So, and take our client's credibility out of it completely. There was testimony at trial from third parties, not plaintiffs or defendants, as to the unemployability of somebody in these fields who had this in their record. In other words, had a dismissal for inappropriate electronic communications, harassment, sexual harassment, et cetera.
Is there evidence in the record that you can get a job if you don't apply for it?
There's not evidence in the record to that effect, Your Honor. I'm out of time. Thank you.
You have some time left for rebuttal too, I think, don't you?
I do.
Yes. Okay. Thank you. Mr. Blanchard? Mr. Blanchard, we're ready to hear from you in rebuttal. You have to turn.
Thank you, Your Honor. Thank you, Your Honor. I apologize. Judge Agee, you asked a question about who prepared the termination letters. Your recollection of the record was correct on that. It's page 1339 in the joint appendix. It's at paragraph 90. The trial court found as a fact that after discussing the matter with Defendant Mitchell, Defendant Peck directed Dr. Williams to prepare termination letters. So you're exactly right. That was the fact. And that was based on what Karen Williams, Dr. Williams testified at trial.
Well, does that help you though? Because it seems like to me that would sort of undergird a finding of actual malice if Mr. Peck had determined, as the district court found, that he was going to fire these plaintiffs because they were jerks, and then he delegates to a subordinate, well, go find me reasons from the village policy manual that will substantiate it. It seems like to me that's not a helpful fact for you.
Well, to go back to Judge Motz's line of questioning about the finding that it was because they were jerks, Your Honor, I think in this case, and this is what Mr. Peck testified at trial, that was a shorthand way of saying, hey, they were jerks and they did these bad things. I think based on the evidence we had at trial, it was very clear that he was the village manager. He didn't know exactly with a lawyer's clarity exactly what each one of these policy provisions meant, but we do have the factual finding, and it's at Joint Appendix 1338, paragraph 83, that Peck believed that the comments were directed at Mitchell because of her sexual orientation, which he found offensive. So the trial court specifically found the fact that that Mr. Peck believed that they were mocking Mitchell for being a lesbian, and he found that offensive. Now, laymen out there, lawyers may know different, but now, under Supreme Court precedent, the law of our land, sexual orientation is in fact covered by Title VII. Making fun of somebody, mocking them because they're gay, is indeed sexual harassment. So I think that the fact that he delegated, look through the policy, Dr. Williams, and this is what I think happened. Look through the policy and write up a letter for me, I don't think it hurts him. Now, again, as Mr. Potter pointed out, we do concede he signed these letters. What we don't concede is that he believed that the statements in them, that they were, engaging in these comments, was false.
The problem with the actual malice, following up on Judge Age's line of questioning, is that it appears that Peck decided to fire these plaintiffs before he knew what the policy provisions were. That seems to lean toward actual malice.
Well, Your Honor, he decided to fire them based, according to the facts found by the trial court, based on what Carolyn Mitchell told him. And the actual belief that he had in his head, according to what the trial court found, was that they were mocking Mitchell because, in part, because of her sexual orientation. So we have to look at subjectively what he believed. And by the way, you raised a good point about actual malice. Remember that in a defamation case, when the plaintiff's a public official, we all agree they are, under New York Times, only provably true or false assertions of fact are actionable. Only true or false, verifiably true or false assertions of fact are actionable. And this is one of the issues we raised. Mr. Peck's subjective motivation for firing them wouldn't meet that test. And I'll give you a hypothetical. Let's hypothesize that he did, in fact, believe that they had violated the sexual harassment policy, but said, well, I'm going to fire you because you're jerks. Same situation. He's lied about his true, not because you're jerks. I'm going to fire you because you're Tar Heel fans. Again, you've proved that he's lied about his subjective motivation, but is it defamatory? No. The underlying policy violations are what you have to look at in a situation like this. And back to your question, Judge Motz, about the jobs.
Well, if you publicly label someone as being, and I think this maybe only applied to two, having perpetrated sexual harassment, are you saying that that's a statement of opinion?
I'm saying that some of the things like discourteous treatment and those other allegations are clearly statements of opinion. But on the sexual harassment one, I think if you looked at the policy, I think it could be a statement of fact, but based on what he believed happened, they would have fit that. He believed they were mocking her.
For defamation per se purposes, it would go to whether or not that harmed the plaintiffs in their trade, or whether or not, and I don't think the district court got to this, it held them up to ridicule within larger society. I mean, those are the elements for, I think, for defamation per se.
There are different ways. You're correct, Your Honor.
If the trial court found that no, Mr. Peck didn't really think they were guilty of sexual harassment, but he just included that in the letter after the fact to make it look good, it seems like that goes a long way toward sustaining the district court's finding on actual malice.
If the trial court had found that he did not believe there had been a complaint and he did not believe that any of this language was offensive, I believe that I would concede that statement's correct, Your Honor. But under the circumstances, what the trial court did find he believed won't support actual malice. And I'm out of time. I apologize.
Do we have any further questions? Thank you very much.
Thank you, Your Honor.
Mr. Potter?
Briefly, I mentioned this before. None of our clients were involved or stated any jokes or made any innuendo regarding Dr. Mitchell's sexual orientation. That has been repeated over and over and over again. That was not stated by any of our clients at all. We have our sort of appeal issues as well, because we do have a cross appeal in this matter. The first one is related to a pretrial motion in limine and its subsequent effect on the evidence at trial involving the admission for purposes of establishing or defeating a defense of sovereign immunity asserted by the village of an insurance policy by the interlocal risk insurance policy pool. May have gotten that wrong, but it's an insurance policy that the village had that would have provided a defense and indemnification on the claims asserted by our clients against the village. Prior to trial.
Well, is that insurance policy in the record?
Is it in the record from the trial, Your Honor?
Mhm.
Yes, it was.
Or the
it would
joint.
have been, as I understand this particular issue, you brought a claim against the village as an entity, and it pled sovereign immunity. And so then the burden would have shifted back to you to show under North Carolina law that that was inaccurate because there would have been liability to the extent of the insurance policy. So was the insurance policy placed into evidence to carry your burden?
Not at the trial, Your Honor. It was not. But what I'm getting ready to
But
explain.
where else can you place it into evidence?
Well,
That's the
there
only
was a
place.
motion in limine preventing it from coming into evidence that the defendants filed in this action. And when Magistrate Swank, who heard the pretrial motions, had the hearing on this, my law partner, Mr. Cox, and Mr. Blanchard agreed that admitting the insurance policy into evidence was inappropriate under established law. And so both sides agreed that it would not be admitted into evidence. The defendants did not raise the defense at trial, and had they, then the burden would have shifted back to us and we would have introduced it. But this is a situation where a motion in limine was filed. It would have been granted, but we agreed with defense counsel that it would not be admitted because it was not properly admitted at trial unless the defendants raised the defense at trial, which they did not do. And
Well,
so
then where's your claim? What's your problem now? You've already waived that claim, that argument.
I'm sorry, Your Honor, I don't understand the question.
You agreed that the insurance policy would not be an issue at trial unless they raised this as a defense, right?
Correct. But the problem is the court ruled that we didn't have a claim against the village because they had raised the defense, and it was our burden to introduce the insurance policy at trial. So I think,
But you could have introduced it. You could have said to the district court, okay, we agree that this isn't a jury issue, but we are making a motion for summary judgment or motion on the pleadings or something with respect to this particular issue. But instead, you just agreed the insurance was not a matter for the jury's consideration and never said anything further, that it was, I guess your argument is that it's for the judge to decide this.
well, our argument is that the defense is the defendant's defense to raise, and that had they raised it at trial, which they did not do, we would have then had a different scenario than what the motion in limine considered. And they didn't. And so therefore we didn't introduce the insurance policy, but they didn't raise the defense either. And it seems like where the court agrees and the parties agree that it's not going to be introduced because it's not proper to be introduced at trial, that you can't then have a gotcha moment after the trial is over and say, even though the parties agreed and the court agreed, you didn't admit the insurance policy at trial.
Well, did you ever make this argument?
It's sort of inverting.
Right.
I mean, you didn't bring it up to the jury because you can't put the policy before the jury. So then it's converted to a bench trial. The problem you didn't say, they didn't bring up sovereign immunity, where sovereign immunity exists for all entities. And in order for you to overcome that, you've got to introduce something to say they waived it. And you didn't.
Your Honor, I'm sorry, I'm out of time.
You can answer the question.
Understand that. I mean, you go to trial and you sue an entity that has sovereign immunity, and your position is we don't have to show that it's got insurance if they don't mention sovereign immunity?
At a bench trial, Your Honor, it's
At
it's
any
still
trial,
it's an
at any
affirmative
trial,
defense.
even with the jury there, ultimately when it comes back, I mean, on damages or somewhere, you got to show that sovereign immunity has been waived. And if it's not been waived, it exists. And you didn't.
Your Honor, it can be waived by failing to raise it, and they didn't raise it at trial either. That's
I'm talking about you. You mean failure to bring up the sovereign immunity would waive the sovereign immunity defense?
The sovereign immunity is an affirmative defense, is my point. It's an affirmative defense. It doesn't exist without being raised. The state can waive sovereign immunity other than through the purchase of insurance by not raising the defense, is my point.
All right, I think you have exceeded your rebuttal time. Unless my colleagues have further questions. I think,
No questions.
thank you very much for your argument. Do we want to take a short break now, or shall we go along?
Let's do that.
Take a short break. Okay, I asked the clerk, we'll be back in 10 minutes. Is that
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Good morning. We're happy to hear argument in our third case, number 201790, Tayel versus Bank of New York Mellon, and so forth. Mr. Brown?
Good morning, Your Honor. Judge Motz, thank you. And Judge Agee and Judge Wynn. My name is Christopher Brown. I represent the appellant Alkesh Tayal in his appeal of the grant 12B6 on the breach of fiduciary duty count against equity trustees, the denial of his motion to remand the case to state court, and the grant of summary judgment in favor of Bank of New York as trustee for a real estate mortgage investment conduit and SPS, the loan servicer. I want to begin by pointing out, putting aside embarrassing typos, an error in my reply brief, and that is on page 15, and the docket page would be 18 of 29, where I say that SPS charged an eviction fee to Tayal's account and numerous other improper fees, including around $68,000 in corporate advances to Tayal's account, more than ever could be attributed to taxes and insurance. And the citation is, see opening brief page 68. It's clearly in error. I meant to cite to the opening brief at page, it's 21 of 35, paragraph 38 of my fact section. And what we have there, let's talk, I want to be clear about what I mean by corporate advances. I realize it's not explained. A corporate advance is made by a loan servicer when a loan is in default to advance certain payments, such as taxes and insurance. And when I say such as, that's all it is, really. There may be an instance where an HOA fee may be advanced, perhaps. And what the discovery documents received reflect was, as cited in paragraph 38 of the second corrected opening brief, what amounts to about $68,000 in corporate advances that were allegedly paid by the servicer, reimbursed, and then they're charged to the account. Which brings us to the issue of material breach on the breach of contract claim. And I apologize to the court if it felt that my argument in the opening brief was sparse. I agree that it was. And forgive me for feeling that this is a fairly straightforward issue on the breach of contract. But I will concede, something like those $68,000 in unlawful charges and an unlawful eviction fee is not a material breach to stop a foreclosure. That can be handled in the back end of the Commissioner of Accounts. When we're talking about whether or not we have a material
counsel,
breach.
as I understand that your argument, you contended that I presume the district court didn't have jurisdiction because it should have remanded the case to the
That is
state
correct,
court?
Judge Agee. That is correct. That is my position. And I can expound on that.
Well, we need to know whether or not we have jurisdiction.
Very good. I think it's clear that there's a fiduciary duty held by a trustee. I have an allegation of claim or breach of that duty by equity trustees. The case law is clear that the duty is both expressed and implied. It's within the contract and beyond the contract, and it will be reviewed by.
What is the breach? What is the breach of the duty you allege here?
The duty is, Judge Wynn, is to remain impartial. And if there appears to be a legitimate dispute between the parties to the contract, the deed of trust, the lender and the borrower, at the time that the power of sale is invoked, there's a duty by the trustee to stop the sale to resolve that legitimate dispute, that bona fide dispute.
So that's based upon what you
is
have
the
represented to him. I'm sorry, Judge. Go ahead. I interrupted.
No, so equity is the trustee under the deed of trust.
The substitute trustee under the deed of trust. They've been substituted in. Yes, Your Honor.
All right. So where do you get this duty from?
From Hudson v. Barham from the Supreme Court of Virginia, from Crosby versus ALG trustee, cited in my brief.
So how does Hudson impose a duty on the trustee?
It imposes a duty to remain impartial and to cancel the sale and seek the assistance of the courts if there's a bona fide dispute between the parties.
I don't think that's what that case says. I mean, it says that there could be a circumstance where where the trustee finds there's an impediment of title, but I think there's actually language in that case that says that the trustee's duty is not to be overplayed in that circumstance. that their duty is conducting the sale. I'm not familiar with any case ever from the Supreme Court of Virginia, which has been sitting since 1779, that has expressed support for that duty that you put forward.
Well, the quote I cite in my opening brief at page 24 is the trustee has an affirmative duty to seek assistance from the court to remove any cloud on title, or if there's any doubt or uncertainty as to the debt secured or the amounts thereof. So,
well, there are conflicts all the time between the grantor and the grantee under a deed of trust.
There are.
I'm not aware of any case anywhere that says in that circumstance the trustee has any duty to stop the sale. I mean, do you have anything from the model jury instructions, Virginia CLE?
Well,
anything that says that?
Well, I am reading the language. The trustee has an affirmative duty to seek assistance from the court to remove any cloud on title. The context of this is a foreclosure. So prior to foreclosing in a non-judicial forum under a deed of trust that includes a power of sale, the deed of trust started to show up in the 15th, 16th century. It was to be interpreted in favor of the borrower. It was supposed to be strictly adhered to protect people from losing their homes to lenders without proper procedures or whatever being followed in a non-judicial forum. In that instance, the trustee is supposed to remain impartial, be an agent of both the lender and the borrower, and before proceeding to sale, if there is a dispute that needs to be resolved that addresses either a failure of a condition precedent or the amounts due or a cloud on title, it has a duty. And in practice, Judge Agee, what that means is they cancel the sale and let us talk to the servicer and work it out. But what the case law says is they have a duty to seek the assistance of the courts.
Well, I don't think that's a fair reading of Hudson, and I'm not aware of any other case from the Virginia Supreme Court that says that. In fact, the Supreme Court said in Hudson, if there are no real impediments in the way of a fair execution of the trust, then its aid is not necessary and the cost of the lawsuit ought not to be added to the cost of executing the trust. Here, all you've got is a dispute between debtor and creditor. Doesn't have anything to do with the title. So my problem is I don't see that you have a cause of action. And even if you did, I don't see how you've pled any damages.
I understand the damages part. Let me speak to the first part of the court's concern. And that is, this isn't even disputed by the defendants. Like, they understand that if there's a dispute, their argument, their pushback against me is, we canceled the sale after you filed the lawsuit. And their argument was, given there's no sale, we cannot have breached our fiduciary duty. That's their position. They're not even saying they don't have this duty. They're not saying what the court is saying right now. That's not their position. They haven't argued it. They haven't raised it.
How you're framing what the duty is. The duty of impartiality, granted. The problem is, does it extend to something such as here, the cancellation of the sale? And if it does, and the trustee, in fact, cancels a sale, then that would support an action by the other side, under your theory, to do the very same thing. So the trustee can't win in this deal. If he conducts the sale, then you say, hey, he breached the duty to me. If he doesn't do it, then the other side comes up with it. And as Judge Agee has pointed out, I think, at least looking at the Virginia case law, and certainly I yield to Judge Agee on that, there's only one case, and that's a trial court case, that even says anything like what you're saying here. And maybe someone ran with that because we're talking about a trustee type thing, and maybe that has some level of influence on the trustee and how you act. But that one case, other than that, there's nothing that I have found says anything close to what you're saying. I agree with Judge Agee on that. And are you relying on that trial court case here for that proposition? How's that working for you?
I'm relying on the Bremer case for the proposition that the trustee's failure to adhere to its duty and cancel the sale on notice of a bona fide dispute results in the ability of a court of equity to, if it feels appropriate, to award attorney's fees to the homeowner for having to go to court because the trustee abandoned its duty. Now, you're right, Your Honor.
Didn't we say in Wilmer we didn't think much of that? We didn't think much
We
of that
did.
argument.
You did, but of course.
You think we would think differently now, huh?
Well, no, I'm not trying to
Understand.
change the court's view. The court was correct in Wilmer. And as I pointed out, there's a distinction. In other words, I don't want to call it confusion when my argument began, but to point out that equity is the trustee to the deed of trust is the seminal point. In Wilner, he was trying to impose that duty on the trustee of the securitized remit, which in this case is Bank of New York Mellon. Bank of New York Mellon doesn't have a duty to remain impartial and cancel a sale or otherwise have any fiduciary duty. The trustee to the trust does. So the court properly ruled in Wilner. There was just respectfully a slight lack of the distinction.
Well, I must admit, having it's been over 30 years since I practiced law, and I have to remind myself of that. And real estate law was something I did quite a bit of. But I'm thinking of a trustee, and even though the trustee is holding something of an equitable title and legal title is with the actual person that purchased it, it still is that equity there in terms of the trustee's fiduciary duty is really something on the part of the bank. And so even though there is that impartiality duty that seems to be apparent here, because it's that's the reason you get someone, a third party involved in this is to make sure you're not going directly against each other. I'm not sure it extends anywhere near where you were going with it in terms of the duties of a trustee. That might be a bit much to make those kinds of calls when, he's to conduct a sale, a foreclosure, make sure that's fair, make sure it's impartial, make sure it's done right. But then the basis for it, there has to be other avenues for you to stop the sale outside of the trustee, aren't there?
Well, in Matthews versus PHH Mortgage Corporation, that was a case where the Supreme Court of Virginia came out and clearly stated that where conditions precedent weren't satisfied, a foreclosure couldn't go forward. And there's a footnote in the opinion that the plaintiff, the homeowner, has the right to go to court before the sale. Now, that didn't happen in Matthews v. PHH. There was no foreclosure that happened, but they did allude to the fact that, not allude to, expressly stated where conditions precedent aren't satisfied, then the power sale can't be invoked. And that's more appropriately what I'm saying. I'm using the figures to say.
Are you saying that it can't be enforced, that they can go to court for it, or by going to the trustee and says, okay, we have here evidence that you shouldn't do this, so stop it? Is that it, or do you take it to the? I don't know how that makes him impartial. He's got to make a decision, and you would like to keep the work of a trustee, for those who have served in those positions, pretty ministerial in what he's doing, and to follow based upon what's before them at the time. Someone comes up with an allegation and says, wait a minute, I've got a problem here. They are overcharging me, and that's the reason I didn't pay, and you need to stop this sale. That could come up in 100 different cases. Every time someone who's in the position of your client can come up with something they perceive to be a valid reason to say, this is why I didn't pay, so stop this sale. But the evidence on his face is showing he didn't pay. Everything is fitting right on all fours with a foreclosure sale. And you got a trustee impartial, but not a judge in the case. So I'm not surprised there's not another case like this, other than the Beamer case. But I don't think that case adds anything to this. In fact, I don't even think it's guidance or anything else. It's not binding on any other court probably not even on the court itself that did it. But
Judge Wynn, I would say it is a reflection of public policy principles in governing this incredible power in a non-judicial foreclosure jurisdiction. And that is so that homeowners don't get run over by more powerful lenders when it comes to the non-judicial foreclosure process. They are for 500 years, for 400 years, it's been very clear that
you've got a lot of other facts in this case that takes this away from your client just being totally innocent in this thing here. I mean, there's a lot going on in this case, and we don't want to get in there. I just want to stick with what we're dealing with right here in terms of this action. If we get into what homeowners do and that sort of stuff, that's a whole different ballgame because, I mean, he just didn't pay. And,
Well, that's
you know,
not,
there's a question of whether or not you went back and forth, but that's not what we need to deal with here. We have a specific issue here. Do you have, as Judge Agee alluded to, even a cause of action that can be brought?
yes. And my time is up. I'd like to save my remaining time for rebuttal, Your Honor, but I can answer if you'd like it, or I can wait.
We'll hear from you in rebuttal.
Thank you, Your Honor.
Ms. Pocock? You're not turned on.
Thank you. Can you hear me now?
Yes, sir.
Okay, may it please the court. My name is Don Pocock. I represent two of the appellees in this case, Bank of New York Mellon and Select Portfolio Servicing. I'm sharing the response time today with Mr. Robert Michael, who represents the trustee equity trustees. As the court has highlighted through its questions during the opening argument, there is no case in Virginia that establishes a cause of action for breach of fiduciary duty occurring before a sale takes place. The only cases that observe a cause of action for breach of fiduciary duty under Virginia law are claims that arise as a result of the conduct of the sale, because the duty of the trustee of impartiality is to ensure that the sale that takes place protects both the debtor and the creditor by being as fair as possible so that the debt can be paid and the debtor's equity can be protected. That's the duty of a trustee, is to conduct a good sale. And so the cases that look at this fiduciary duty, which is imposed outside of the terms of the deed of trust, observe that a trustee breaches his fiduciary duty if he engages in some sort of self-dealing or collusion with the purchasers, fails to conduct a proper sale or fair sale, or where the sale price itself is grossly inadequate such that it shocks the conscience.
If we agree with the statements you just made, does that end the case?
It ends the question as to removal, and it ends the question as to equity trustee, because the case was properly removed on the grounds that there was no possibility of any recovery from the trustee, and therefore jurisdiction is proper in the district court. As you've highlighted, that's a threshold question and critical to the analysis today. There is no cause of action against the trustee when a sale does not take place. This sale did not take place. The district court acted appropriately in dismissing equity trustee and denying the motion to remand. Even if there were a cause of action for breach of fiduciary duty, the remedies that are available against the trustee are very limited. They're either you enjoin the sale or you rescind the sale. But there's not even a case under Virginia law that establishes that there is a claim for damages against the trustee. If the sale has not taken place, the sale should be enjoined. If the sale has taken place, it can be rescinded and set aside. But even under those circumstances, the trustee would still be a nominal party, because the trustee has no interest whatsoever in the outcome of that case. Here, there was no injunction sought. The sale didn't take place, that's true. But the fact that the sale didn't take place, and we make an issue of that in this case, is not to hide behind the facts of the case or to avoid liability. The arguments that have been made in the appellant's brief seem to impose upon the trustee a responsibility to advocate a claim on behalf of the debtor. And the trustee doesn't have that responsibility.
Let's assume, counsel, that our jurisdiction's appropriate here. Mr. Tayal says he didn't have to pay.
Correct.
So what's your response to that?
Well, the breach of contract claim that's alleged here is based upon a loan modification agreement that was attached as an exhibit to the complaint and as plain as anyone can see. The modification agreement provided for a specific payment, over $7,000 a month. Mr. Tayal accepted those terms and didn't perform them. And there was no evidence whatsoever that he ever attempted a $7,000 payment, or that he tendered one that wasn't accepted, or anything else, except for the fact that he disputes that the written agreement is not actually the deal. The allegation on this breach of contract claim is that even though there's a written agreement, there was some other agreement for a lower payment, which is contrary to law. Mr. Teal was presented a copy of this document. It was in writing. He could review it. It was even highlighted ahead of time as to the amount of the payment and was asked whether or not that made a difference in moving forward with it. It was accepted. The evidence showed no genuine issue of any material fact, that my clients billed the account consistent with the loan modification agreement. There was no payment made. That's a default. There are a lot of arguments that are made in the appellant's briefs about something called lender-placed insurance. This is not a case about lender-placed insurance. Lender-placed insurance has to do with situations where the debtor is making payments on their loan and insurance lapses and a policy has to be provided to cover. That's not what happened here. What happened here was this property was foreclosed, title passed, it was in the name of the bank, and this loan modification agreement was negotiated as a means of resolving a suit filed in 2017. So the type of insurance that's at issue here is more properly labeled something called REO insurance, and that's to cover the lender while the title's in their name. But the point is that this insurance was not imposed due to some sort of term or condition in the existing note and deed of trust. It was imposed because title had passed and it was disclosed, and the cost of it was very high, and that was disclosed, and Mr. Teal accepted that and agreed to pay it. And after the loan modification agreement was signed and my clients began billing the account again, they managed the account consistent with the note and the deed of trust. Statute called RESPA is the federal law that governs the administration of escrow accounts. And RESPA does not require that an escrow account be analyzed or adjusted just whenever the debtor deems it to be the case. RESPA requires that an escrow account be managed once a year. Well, here the theory of breach of contract is that my clients had a responsibility to adjust the escrow payment immediately, as soon as the loan modification agreement was signed. And there's no term anywhere in any contract that imposes that duty on my clients. Now, they did, in fact, conduct an analysis of the account. They did, in fact, analyze it consistent with RESPA. They did, in fact, reduce the escrow payment later on, and they serviced the account. And there's no evidence that they didn't service it consistent with federal law. The fact of the matter is, Mr. Teal just didn't pay. And Mr. Teal has taken the position that he doesn't owe any of the prior payments because they were too high in his estimation. That is not a breach of contract case. There's nothing in either note or deed of trust or loan modification agreement that would impose the duties that are assumed in the breach of contract claim asserted in this complaint. The district court recognized that. The district court looked at the evidence and saw that the statements that were sent to Mr. Teal were consistent with the loan modification agreement, found that there was no genuine issue of any material fact, properly dismissed the case. Your Honor, I see there are very few questions. At this point, I think I've covered the points that I intended to make. We ask that this court affirm the district court in full, that the denial of the motion to remand should be affirmed, the dismissal of the trustee should be affirmed, and that summary judgment in favor of my clients should also be affirmed.
Thank you very much. We'll hear from your colleague, Mr. Michael.
Thank you.
Thank you, Judge. Good morning, and may it please the court. I'm Robert Michael. I'm appearing today on behalf of Equity Trustees. As you have heard, Equity Trustees was the trustee under the deed of trust that is at issue here today. I'm going to jump right into the duty issue because the duty of a deed of trust trustee in Virginia is well established, has been for a century in Virginia. It includes all of the duties that are contractual in nature and may be laid out in the deed of trust, and the only extra contractual duty, the only common law duty imposed upon a trustee in Virginia is the duty of perfect fairness and impartiality. The appellant's counsel has said that the trustee can't proceed when the borrower comes forth and makes a legitimate claim. And I would agree with that if they've made a legitimate claim. There are lots of caveats to what the appellant's counsel has said that I think are required to be pointed out to the court. It's an exacting standard, the duty of perfect fairness and impartiality. But I believe that the record shows that equity trustees satisfied that duty in this matter. Mr. Tayal will ask you to impose a duty of partiality, a duty where the borrower is treated partially to the lender. If he comes forward and makes any allegation of fact, unfounded or otherwise, that he says he thinks you want to cancel the sale over, trustee is required to cancel the sale, proceed to a court of equity and post a case on his behalf. And that is not impartiality. That is a duty of partiality that Mr. Tayal is seeking to impose. This court is an impartial arbiter of justice, but it makes decisions every day based upon facts and law. And when a trustee is presented with documents from a lender and information from a lender, it has every right to rely upon those documents and information. Supreme Court has said exactly that.
What happens at this point? I mean, he sought to have the trustee to cancel the sale, files the lawsuit, and that cancels the sale, as I understand it. So the sale hasn't happened yet. What's going on with the case at this point? Ultimately you can achieve a result by doing things that like this, maybe file a lawsuit. If that cancels the sale, that does what the trustee didn't do. And what's going on with the property now? I guess it's kind of off the record, but it's interesting to me, at least the procedural posture of where we are and the kind of novel question that's before us.
Well, Judge Wynn, I think that's a really insightful question. And right now, there is nothing happening with the property. Virginia employs a wholly non-judicial foreclosure process. And unless and until a trustee comes and schedules a new sale, which it won't do until it is requested to do so by the lender, there will be nothing happening with the property. Mr. Tayal still owns the property. And again, it's beyond the record, but it's my understanding he's still renting the property to a person and profiting from it. So there's nothing happening with the property at all. And the filing of the lawsuit didn't automatically cancel the sale. The filing of the lawsuit just perhaps caused the impetus for the lender to ask for the sale to be canceled. There are many circumstances in Virginia where a trustee, in the face of a lawsuit, will proceed to foreclosure. And that was the case in the Virginia Supreme Court case of Tamara Young Allen versus Bank of America and Equity Trustees. It's a 2020 opinion. It's cited in our briefs. And in that case, the facts are on all fours with this case, except that the trustee proceeded. The borrower in that case alleges that the preconditions to foreclosure and acceleration haven't occurred. Trustee looks at the allegations, looks at the lender's records, determines that those are unfounded allegations, proceeds to sale. And the Supreme Court says that the trustee doesn't automatically violate any presupposed duty by proceeding to sell under those circumstances. And if the law were that way, it would require a duty of partiality. In fact, the Supreme Court says it would grind everything to a halt. Enforcement of deeds of trust in Virginia, it would create an opt-in.
Why did the trustee not continue with the sale then, in this case?
I'm not certain it's in the record, Your Honor, but the trustee was requested by the servicer to cancel the sale, which the trustee would always do. And in Virginia, when there's a contest, a trustee would prefer, a proper trustee, I would suppose, would prefer to have the parties agree. And so Mr. Tayal comes forward and says, we'd like you to cancel the sale. Trustee looks at things, says, we don't think there's a proper basis to cancel the sale unilaterally. But if the servicer comes forward and says, hey, we want you to cancel the sale, we see a lawsuit out there, we want to resolve that. But the trustee is the fiduciary to both parties, and both parties want the sale canceled. Trustee does so at that point, and that's what happened here.
Well, it just seems to me, and basically you're saying the bank was okay with canceling the sale on it. And I mean, a lot has happened in the last few years with property. Now you got a piece of property over there that the plaintiffs own, and I don't know what it's worth at this point, but it's an interesting scenario of how procedurally something has happened here that couldn't happen, but it happens anyway, which is the cancellation of the sale delays it, and circumstances change. I don't know where this case is going from here, but those are extra questions, and I was just curious about it. I think we've fleshed out the other issues pretty well.
Thank you, Judge. I see that my time has expired. May I briefly just ask the court to affirm the dismissal of the trial court of equity trustees, and I appreciate your time.
Thank you very much. Mr. Brown, do you have some rebuttal?
Thank you, Your Honor. Let me begin by saying very respectfully that the only context that this whole concept comes up of the duty to remain impartial and seek the assistance of the courts is in the foreclosure context. It never comes up if it's just a random letter you want to send to your bank or your servicer. If the court looks at the letter I sent to equity trustees dated March 18th, 2019, it's a JA 106. I'm explaining my efforts to try to get the servicer to recognize the problem. So then I present that problem to the trustee. And the duty for the trustee is to remain impartial, to not injure one side or the other. If I present them with evidence, not allegations or spurious or meaningless things, that a condition precedent hasn't been satisfied and the power of sale can't be invoked because there is, in essence, no default, then
why is your lawsuit not directly against the bank or the servicer instead of the trustee? I mean, it is the bank that you say is forcing a foreclosure illegally. And that would sort of take that might be a reason that then it would be canceled, but you're attacking the trustee for not doing something here.
Well, I had a declaratory action count, Your Honor, the original complaint, but once the foreclosure is canceled, I don't need the declaratory action that the bank can proceed to foreclose, and the foreclosure would have been in error. And let me be clear, the Young Allen opinion was a little different.
So you're saying that if the bank hadn't canceled the foreclosure, you would have proceeded on with the declaratory action?
Yes, because the rights of the parties would have been at issue before the court, before the foreclosure had gone forward, but they decided to go forward. Yes, I would have. But I want to be, I have 5 minutes to try and get this court to persuade this court to understand this trustee duty is very important. It affects homeowners all across the Commonwealth.
But no one's going to take that job if they have this kind of duty on them. Who would take this job?
Well, because they get paid by the bank.
Knowing you face this kind of liability, can you imagine the trustee malpractice insurance rates and stuff on this case?
Well, they're not lawyers, but it's an interesting setup. There's a statute that allows the conflict. They serve as counsel for the bank with under their other name, Bierman, Ward, and Wood. And then the related entity, equity trustees, the other name on their door, becomes the substitute trustee. And that's allowed. But it doesn't mean that conflicts are going to be ignored. They still have a fiduciary duty to the borrower to not let the lender run roughshod over that. And if there's no duty of the trustee to cancel a sale in light of a bona fide dispute, you'll have all these lenders out here just saying, just foreclose. And once you foreclose, look at Young Allen. There's not a whole lot a borrower can do. So let's just ignore anything the borrower says and foreclose on them. That cannot be the public policy statement this court wants to set. The trustee has a duty to both parties and to not foreclose if the right to foreclose is not there. And if I present the trustee with sufficient evidence that the right to foreclose is not there, then they have their duty is to cancel the sale. And our real dispute here today is about whether or not they're waiting to cancel after I file a suit entitles me to attorney's fees. And that's where I cited the Rolex v. Atlanta Coastline Railroad Company case from this court in 1951 that basically says a court of equity may or may not award attorney's fees if it feels it was an exceptional case. And the issue here is for the motion to remand, can the court say there is no possible way under the standard for fraudulent joinder that I could have prevailed in a state court and had a state court agree to award attorney's fees for equity's failure to respond to my letter and cancel the sale, forcing me to go to court when the case law says they have to go to court and seek the assistance prior to going to sale. That's the context. That never comes up if it's not a foreclosure. Whether you look at Squire versus the Squire case I cited, there's Parrish versus Fannie Mae that I didn't cite. The Matthew versus PHH opinion is of assistance. And the Crosby versus ALG trustee opinion is great because it really reasserts that there is this duty to remain impartial. Now the breach, I advise them.
You say this is Virginia law, and it's very difficult to determine that. Nobody seems to indicate it, but you think you would prevail if we certified that question to the Supreme Court of Virginia?
Well, on that issue, with respect to Robert Michael, fine gentleman, just conceded. Yes, we have a duty to cancel a sale. If we have a reason to do so, we have to make that call. He just conceded that. And in this case, the lender told them to cancel, okay, which is a further problem. when they have the duty to remain impartial, they shouldn't be waiting to hear from the lender. But that's another issue. I think I would prevail on the certification of the duty. I don't know if I would prevail. I believe I could prevail on the issue that the failure to cancel it results in the borrower incurring attorney's fees, just as you said in the Rolex case, right? You say, about how when the damage is the inconsequential result and so in favor of one party or the other. Look where we are. My client has had to go to court, fight motions, go to an appeal, all to resolve a pretty clear dispute on the face of the documents. Did my client not pay? No. Did he not comply with the terms of the loan modification of the original loan docs? No. The loan modification said the payment was $4,000 and provided an estimated escrow payment. It was understood and agreed by counsel for SPS that the REO insurance counsel spoke of can only be in place when they own the house. That makes perfect sense. So why in the Cyphus affidavit does Mr. Cyphus say they placed those charges on my client's loan balance? They're just the purchaser at the sale.
I just want to leave. Is this the way a case like this should be handled? I mean, is this the way someone who's in position of client should handle this? That you just don't pay, you dispute it, goes to foreclosure. What if you paid and then you brought the action against the bank for failing for overcharging you? I mean, there are all kinds of statutes that deal with stuff like that. You know,
that's a power play.
Trade practices that can treble fees and do a lot of things. There are a lot of disincentives for banks to overcharge.
Correct.
So why would you go this route?
And with the last 20 seconds, I want to say why. Because my clients, homeowners out here, are not billion-dollar financial institutions. And when they're faced with a $7,000
client's a real estate agent, isn't he?
Well, that doesn't mean he's rich.
I didn't say he was, but I'm asking
he's
savvy in
job,
terms of how to handle real estate matters. He understands that. He's not the regular guy who's just buying a house out there. He understands banks. He understands this whole transaction. This is not an ordinary home transaction.
My time is up, though, Your Honor. I see.
You can answer the question.
Sure.
You don't pay because they can't charge you a fee for whether you want to call it LPI or REO, and they can't declare a default for a failure to pay a fee they can't charge you for. And if they won't accept a partial payment, the court is saying, we'll just put out the $21,000 for the first 3 months and then go to court and try to get your money back. Yes, that's an option. But when we're talking about who we're dealing with here in a non-judicial foreclosure state, when we're supposed to be protecting borrowers from shenanigans by servicers, which is what this is. There's $70,000 of corporate advances out of my client's account, an eviction fee, LPI insurance that he shouldn't have to pay for, REO insurance that why would that be on my client's account? They acknowledge it should come off as soon as title was in his name. They don't take it off, and they don't want to remove it until June 1st and declare a default because he didn't pay what they can't charge him for. And the result shouldn't be where we are now. It should be they cancel the sale and we work it out. But unfortunately, this is where we are because of the posture that the trustee's decision put us in.
All right, I think you've answered the question. Thank you very much.
Thank you, Judge Mons. Thank you.
We will go directly to our fourth case as soon as we have the lawyers with us.
Ms. Harrison, if you could unmute your audio and video.
Glad to have you with us. We're happy to hear argument in our fourth case, number 201163, Timpson versus Anderson County Disabilities and Special Needs Board. Ms. Harrison.
Thank you, Your Honor. May it please the court. Your Honor, the lower court decisions were so riddled with errors. We would ask that the court reverse the orders of the lower court and grant summary judgment, our request for summary judgment and a directed verdict or a new trial. I'll start with the errors on the statute of limitations. Your Honor, during the preliminary hearings, the judge recognized there was a discovery rule issue. Up until 2013, the family had not been informed about injuries, sexual assault, ongoing problems that represented violations. In 2013, when Johnny Timpson's arms were burned, she was told, you have to go get a power of attorney before we'll give you records. She got the power of attorney and they said, no, that doesn't work. You can't do that. And let me back up a little bit. Our clients are Johnny Timpson, who is a person with pretty severe mental incapacity. He has the intellectual capacity of a preschool child, and his sister, Sandra Timpson. Your Honor, so the court erred in not applying the discovery rule. Then we get to the issue of the ADA one-year statute of limitations. We shouldn't be back here at this court with this argument again. We resolved that in Stogstall. The court resolved that in Seminole. These agencies that have 12 private lawyers are still arguing that the South Carolina Human Affairs Commission law controls. It does not give a right of action for violations of public service accommodations. It only allows those for race, color, religion, and national creed, national origin. So, Your Honor, I found 45910, which is a statute that applies to hotels, motels, restaurants, and boarding houses. So that state statute doesn't even apply to services that we're talking about here. So the statute—
Counsel, let me ask you a question. Let's just assume that you're correct and that there should have been 2 more years added under the statute of limitations analysis. Does that make a difference here? I mean, for the extra 2 years, what have you alleged or offered in proof in terms of either injury or damages?
It makes a difference as to the retaliation against Sandra Timpson when she tried to obtain records and they attempted to delay his leaving the home. And when they failed to inform her of other services to try to set him up to fail so he'd have to come back. So it affects Sandra Timpson's claims as to retaliation. I think, did I answer that question, Your Honor?
What about the rest of them?
The rest of
the claims?
Well, it affects others in that it goes back farther because this abuse had gone back for years. So there was historical, there were assaults, there were sexual assaults that that the family wasn't being informed about. So we believe that, and the 1-year statute of limitations, it's so important, Your Honors, to establish that the court thought they did it in Stogstall, but these defendants need to be told specifically that the 1-year statute doesn't apply. Lawyers across the state continue to tell people with disabilities there's a 1-year statute of limitation and not take their cases.
But what I'm asking is, Judge Agee asked a specific question and you addressed it regarding Sandra's retaliation claim. What about the 2 years on the other claims? I mean, what is there that says it makes a difference?
I'm sorry, I'm not sure I understand the question, Your Honor.
Takes by going from 1 to 3 years on the claims other than Sandra's?
The ones other than Sandra's, he only went back 7 years. And prior to the 7 years, there was a historical pattern of abuse.
You didn't make this isn't a class action, right?
No, Your Honor, and it's not a class action. And the district court made a big issue of that. But Your Honor, I call your attention to the Olmstead case. It doesn't have to be a class action to require the court to look at systemic violations and not just the violations of the individual. Lois in the Olmstead case was an individual. 2 individuals brought that case. It was not a class action, but the court looked at the system and whether individuals like Lois were also being segregated. And that's what we have here, Your Honor.
So if you're assuming you're correct that you get 2 years added back on the ADA, how does that cover a claim by the sister?
Because retaliation against her, the attempts to prevent her from taking him out, occurred more than 1 year after the lawsuit was filed. It would have been covered within 3 years. They had her go get a power of attorney. They attempted to delay his release, and that showed that there was retaliation against her. There's also retaliation against Johnny, because once he talked to law enforcement, there's multiple unexplained injuries where Johnny's saying they're beating me up.
So,
Did I answer
so
your-
help me out. Help me out. This is where I'm kind of getting a little confused. I think Judge Marks alluded to, is it a class action? And Judge Age's question, I'm trying to understand, what are those specific issues as to Johnny? I got the systemic issues, but what are the Johnny specific issues as to his injuries that you
Yes,
bring
sir.
up?
The court has said, and Judge Agee, you acknowledged in Pashby, that segregation in and of itself is discrimination. So Johnny lived in a segregated environment where they had an obligation to inform him of his right to live in a less restrictive environment. And then even after he was released, they refused to give him services until we went through 2 levels of appeal. And his condition deteriorated to the point that he spent 1 month in a mental institution, suffering tremendous emotional trauma. He was out in the road, waving his hands at cars, telling the police, just shoot me. That was trauma that he suffered because of the segregation, because of the treatment, when they were violating the ADA and violating his right to live in a less restrictive setting. So that continued even after he was released. If I've answered that, I'd like to go on to the ADA and rehab issues. The court dismissed our Rehabilitation Act claim in a hearing in 2018, and gave no explanation. Your Honor, we have shown that Johnny met his prima facie case to prove that he was a disabled person. The court erred by placing the burden on us throughout the litigation. In Olmstead, it's clear. And in cases since then, there's a DC Circuit case, 2019 case, where the courts have said, once we meet our prima facie case, the burden shifts to the government to prove that what we asked for would cause a fundamental alteration. Because of that error, it infected the whole decision of the jury. Your Honor, I'd like to talk a little bit about the Tort Claims Act. The court instructed the jury that the standard of care was slight care. As long as they provided slight care, they met their obligation. The court totally ignored the controlling case of Madison versus Babcock Center. In that case, the slight care standard is not in the Tort Claims Act. It's not in the statute. That standard was established by the Supreme Court, and the Supreme Court established a carve-out in Madison where they said if there is a special relationship with the individual, and they said when you have an individual with intellectual disabilities in a group home, the agency and DDSN have a direct obligation to that person. In Madison, they said, we don't care whether there's a criminal act. You still have an obligation. The court was totally in error when it said, well, DDSN, for them to be responsible under the Tort Claims Act, the group home employees had to be an employee of DDSN. That the Supreme Court totally rebuked that in the Madison case. They said that an independent contractor, that DDSN is responsible for the acts of an independent contractor. The court said in Madison that you have to look at the standards, you have to look at the regulations. This gets into our exclusion issue. The district judge was not familiar with the hybrid witness. We had identified hybrid witnesses in December 2016. There was no objection till trial. We had 2 former members of the governing board of DDSN. We had an individual who had conducted investigations at DDSN. They were not allowed to testify. That's where we would have shown the standard of care that the agency was responsible for. So that was an error, one, to not let them testify as experts. And then even though he allowed Ms. McPherson to testify as a fact witness in front of the jury, the judge told the jury she is not an expert. So that tainted any testimony that Ms. McPherson, who had decades of experience with the agency, as well as having been on the governing board. This gets us, Your Honor, to the, well, and then we have the issue of Johnny not being able to testify. In Madison, the court talked about that. Just because a person doesn't have the capacity of an adult, they should not be excluded. Johnny knew what model of car he came in. He knew President Trump was the president. He answered most of the questions correctly, but we were limited in what Johnny was allowed, the plaintiff was allowed to testify about, and that was a legal error. The 1983 case, Judge Motz and Judge Wynn, y'all were on the Doe v. Kidd panel. The agency is still ignoring the reasonable promptness mandate. They failed to inform him of the services he was entitled to. When he left, he had 0 home-based services. We filed an appeal in January, and the fair hearing process wasn't over until September. So that is more than the 90 days allowed that the panel said was a standard in Doe v. Kidd 1. As to the feasible alternatives requirement of the Medicaid Act, Your Honor, they had the obligation to inform him of the home-based services that were available. We've alleged that they violated 1396 NC2, which required them to protect the health and welfare of Johnny Timpson and to assure the financial accountability of the program. Judge Agee, you in your opinion in Pashby talked about the importance of looking at the resources of the state, and you are absolutely correct about that. That's what Olmsted said. When we tried to show the resources of the state, and it actually cost more when they limited home-based services, this court and other district courts have refused to allow us to put in any evidence about the agency's failure to provide federally mandated cost reports and the fact that their budgets have increased by hundreds of millions of dollars, but yet they're not providing the services that they're required to provide in the least restrictive setting. Your Honor, as to Defendant Haley, twice she's been ordered in this case and another case to give a deposition. Twice the court has changed its position on that. The court granted Governor Haley's motion for summary judgment sua sponte. She didn't file a motion for summary judgment. We were not allowed to put into the record Ms. McPherson's letter and all of her communications with then Governor Haley about the systemic abuse and neglect in the system. I see my time is up. We would rely on our briefs on the remaining issues, Your Honor.
Thank you very much. Mr. Frawley?
May it please the court. My name is Patrick Frawley. I'm an attorney with the Davis Law Firm in Lexington, and I will be arguing on behalf of all of the defendants in this case. One thing I want to point out before we get too far into this is one of the things that Ms. Harrison has argued was that the family was never informed And obviously Sandra Timpson is one of her two parties. Sandra is a sister of Johnny Timpson, but there was another sister of Johnny Timpson, and Angela Timpson, and Angela was never called to testify in this case. Angela shows up in a statement to an Anderson County Sheriff's deputy making a remark about Sandra now being in the family when she had not been for a period of time, and for purposes of financial exploitation, which in their briefs, the plaintiffs have said that was said by the Anderson County DSN board. It was not said by them. It was said by Corporal T.L. Anderson, or T.L. Johnson, rather, of the Anderson Sheriff's Department in his investigation, quoting Angela, who never testified in this case. So when the plaintiff argues that the family was never informed, the only person that testified at trial from this family, in addition to Johnny, was Sandra Timpson, not Angela Timpson, who'd been along for quite a while. She also
could Angela have been called by both parties?
Could have been, yes, ma'am. But
so you could have called her.
I could have called her. I did not. They listed, I think, 25 witnesses. I had 5, and all 5 of mine testified. Yeah, that's correct, ma'am. But when she says that that the family was not told, she's selective in who among the family testified for the plaintiff. With regard to the ADA and rehabilitation issue, that we addressed that in arguments D and F of our brief on pages 28 and 38. The district court held in December of 2018 its ruling on ADA and was dismissing it at that point, but then kind of changed its position within a 10-day period. And in a text order December 28, 2018, it held its ruling on the ADA in abeyance. That's Joint Appendix Volume 7, page 3196. Eventually, he did dismiss the claims against all the defendants except Anderson County DSN Board. That one of those claims went to the jury. And the jury returned a defense verdict on that claim. The plaintiffs argue in issue 1, their arguments are conclusory. She doesn't cite, the plaintiffs don't cite evidence to the record. They make bald statements without attribution to evidence or testimony.
Well, counsel, let me ask you the same question that I put to opposing counsel, which is, assuming that the district court erred on the ADA statute of limitations, so there should be 2 additional years of potential claims. What's your position on those 2 additional years? Is there evidence in the record as to ADA claims? Are they pled for those extra 2 years?
That's a good point, Your Honor, and we make that argument in our brief.
Well, no, I'm asking you a question about what's in the record and whether or not there are claims for those 2 years.
Yes, sir. There are not. There is nothing in the record as far as what took place. Ms. Harrison, in her argument, said that there was a history of abuse, a long history of abuse. There isn't. This was essentially a personal injury case. There were burns to Mr. Timpson in May of 2013, and as soon as Sandra Timpson was on the scene after that, there was 3 in quick succession in July and August of 2013. There were complaints about assaults on Johnny, all 3 of which were turned over to law enforcement, all 3 of which were investigated, and all 3 of which were dismissed. There's no evidence of a claim. So the one response to the 2 additional years of statute of limitation is, well, where's the claim? You know, if you have the 2 years.
So when was the suit filed?
The suit was filed in I think April of 2016, there was an amended complaint filed July
So
8th,
the
2016.
the items that you have just reviewed were within the statute of limitations period as the district court held.
Yes, sir. The May 2013 burns were within that period, and the 3 alleged assaults were within that period. Yes, sir. The things she talks about, sexual assaults and so forth. First, they don't have any evidence in the record establishing that. There was nothing proffered for that. They listed over 207 documents, exhibits that were going to go in. Of those, 25 actually went in. In arguing and making their argument in their brief, they don't cite to the record. They make statements of things that went on. The retaliation against Sandra. To this day, I don't know what retaliation there was against Sandra. In our plaintiff's exhibit number 3, that is the case notes. There's reference to Sandra's first request to remove Johnny in I think the first call was in May, I think May 7th of 2013, which is around the time of the burns. That's when she comes in and says, I'd like him to go to a CTH2 facility nearer my home. She lives in Greenville. Anderson County is, I think, maybe 60, 70 miles away. And that call was to Geraldine King of the Anderson County DSN board.
So I'm trying to understand where you're going with this, but I guess I want to follow up. With the 2 years, the jury did not consider the claims that occurred between February 2013 and 2015. And you are pointing out things that happened in May of 2013, and there were complaints about the treatment that Johnny was getting in the summer of 2013, and she ultimately had to withdraw him from one of the facilities, Tiny Gear, in August of 2013. Why is that not at least, because the jury didn't get it, and if the statute of limitations has been extended for 2 years, at least arguably protected conduct under the ADA?
Well, it was, Judge Coggins had a 1 year plus 5 year. There was a 5-year extension because of his mental condition. So it was actually, it went back 6 years. And in that period of time,
what did moving it 2 years do then? What did the adding it, moving it from 1 to 2 years do?
Nothing. There's nothing argued in their brief. No attribution to evidence or proffered evidence, or what claims would have been made at that time.
So how does that differ from Johnny? And because the extension was on Johnny's claims, how does that apply to Sandra?
The 5 years would not to Sandra. No, sir.
Well, that's what I'm asking you about. I'm asking you about Sandra in those 2 years.
Well, what Ms. Harrison just argued was some kind of retaliation claim against her, but that simply did not happen.
Well, I'm just pointing out, at least in terms of it, and we don't have to make the determination of whether it was or was not. The question is, the jury didn't get anything from her during those time period because those are 2 extra years. And there's evidence in the record that she filed complaints about his treatment during the summer of 2013. You've even articulated some of it in May.
Yes,
and then she withdrew him from this facility from the gear in August of 2013. And why is that not potentially, arguably, something that's protected under EDA insofar as Sandra?
I'm not quite sure I understand Your Honor's question.
In other words, she may have suffered some type of adverse reactions when she withdrew him, and she continued to use those food stamps and all that stuff during that time period. Nobody told her that she could get those PCA payments. There's a lot there with regard to Sandra, and I just don't understand. I got the Johnny extension and the other, but that 2 years we've heard, that's not before the jury. And the question is whether there's sufficient evidence to take it for the retaliation.
Your Honor, there was ample testimony from Mr. Thompson, from Ms. King, about what went on between the time that Sandra made an appearance and wanted to remove Johnny from Anderson County and put him in a CTH2 facility closer to her home. That they had I think it was August 7, they had a conference call with several people in Mr. Thompson's office.
So I want to be clear, please, in terms of my question. I'm not questioning that there is some evidence on both sides of this. I'm not questioning that. I'm just saying it wasn't given to the jury. It wasn't even an issue in the case as to whether that conduct constituted that. And they have some evidence when we look at it there, that it puts it there. Why is that not sufficient to send it back to be considered her retaliation claim for that 2-year period from February 13 to February 15?
There was just nothing that was in there from the first instance of her involvement was in May of 2013. And from that point forward, everything went to the jury at that point. There was no evidence of other acts or injuries to Ms. Timpson before.
There wouldn't be the need be if there's a statute of limitation that doesn't reach back in that time period. And even so, the jury couldn't decide it because you got a statute of limitation that prohibited that 2-year period of time.
Well, I agree with Your Honor. Had something been put in the record or had there been some indication that there was an injury that predated that and went back within the extension, I agree that didn't get to the jury because of that. But there was never anything throughout the discovery process until the 2013 issues that came up with Ms. Timpson. And after that, the evidence that was put in from Mr. Thompson and from Geraldine King and our plaintiff's exhibit number 3, which were the notes of those meetings and those conference calls, everything that was done at that point was to begin the process of getting Johnny out of Anderson County and putting him into another CTH2. Ms. Harrison mentions the issue about least restrictive settings. In 2008 and 2009, Johnny was at an SLP2 facility. They put him in a lesser restrictive facility there, but because of his tendency to elope, that after 9 months, they had to bring him back in. On the issue of whether the family was informed, Johnny's mother was involved in the team exchange or team meeting when he was put into the less restrictive setting. And when they determined that they had to bring him back, Angela Timpson was involved in that team meeting. So there was involvement with the family, and there was an attempt to put him in a lesser restrictive setting. There was also testimony from L.A. Taylor, who was the manager of the home, where he testified to the configuration of the home as far as whether it was an institution or not. That's
Counsel. Counsel,
yes,
I really don't understand what your answer to my colleagues has been. I thought you got what seems to be an improper ruling with respect to one period of statute of limitations. And what you say to us in response is, oh, there was a lot of evidence before the jury that helps us. That's fine. But what about the evidence that they weren't allowed to put in, the asserted evidence that they weren't allowed to put in because of the assertedly erroneous statute of limitations ruling?
Well, Your Honor, my response to that would be that in their argument, they don't cite to proffered evidence in their brief. That would be it. And I agree. I agree that if there's a statute of limitations point where you can't go before that, you're obviously not going to be allowed to put evidence before that. I agree with that.
So that all of your talk about the evidence really doesn't go to this issue, right?
No, ma'am. It goes to what took place with Sandra's first coming on the scene and first.
Well, that's your assertion to us, but
yes, ma'am.
We don't have evidence with respect to 2 years, right? You say there's been no proffer.
That's right.
But there's no evidence.
no evidence.
When was the statute of limitations ruling made?
I believe it was in December.
No, in the context of the trial of this case.
Would have been on the first or second. I mean, it was early in the trial. It was early enough that it would have precluded anybody putting in evidence of anything going back to what Ms. Harrison is arguing the statute of limitations was.
Is there a place in the JA where there was discussion of this issue?
There was, but I don't have that in front of me right now, Your Honor.
Okay.
I know there was a discussion with Judge Coggins where he went over with everyone about what the statute of limitations was with the additional 5 years for Johnny. He set that out and he referred to it as a look back. And that is cited. I believe we've cited that in our brief.
Well, so when Judge Coggins discussed the whole case, did he say, but they haven't put in this?
No, ma'am. I don't recall any discussion like that. Your Honor, with regard to the plaintiff's argument on slight care in the Madison case, they've misinterpreted Madison. Madison does make reference to the South Carolina Tort Claims Act, section 15-78-60, paragraph 25, as requiring a plaintiff to prove gross negligence. And then we've cited the court to Etheridge versus Richland County School District, which is what defines gross negligence, one of the definitions being the failure to exercise even slight care. That's where the slight care reference comes from. And in the Madison case, the trial court there recognized gross negligence as being the standard, and said that it concluded that the issue of whether the defendant acted in a grossly negligent manner or not was a factual issue for the jury, and left it to the jury on that. That was on page 661 of that opinion. That's exactly what Judge Coggins did. He sent that issue under the Tort Claims Act, which was one of the causes of action remaining against the Anderson County DSN Board and the DDSN, sent that to the jury with an appropriate charge in his 64-page charge. Your Honor, with regard to Your Honor's question about the 1-year statute, that's on Joint Appendix page 4965. That's day 1 of trial. That was 4965, Your Honor. With regard to the hybrid witnesses, Ms. Harrison talked about that. They were not disclosed as experts through discovery. Mr. Thomas and Ms. McPherson were both allowed to testify as as facts witnesses. Ms. Harrison said that the trial judge told the jury she is not an expert. She was put up as a facts witness. She was allowed for that. Mr. Thomas had no personal knowledge of Johnny Timpson in his testimony, and there was just brief cross-examination of him by the defense counsel. Ms. McPherson testified to nothing about Johnny Timpson on direct, and defense counsel chose not to even cross-examine her. The remaining witness was Ms. Mullis. Mullis had not worked with Anderson County DSN Board nor Johnny Timpson since 2003. This was a May 2019 trial, and she was excluded based on that. Johnny Timpson's testimony, Judge Coggins did have a hearing, a brief hearing with regard to Johnny. Johnny had a limited ability to respond. With regard to his age, he was said he was 50, 51, and so forth, and just kind of let that go. The court kind of left it where that was. Your Honor, I see that my time's almost up. We asked the court to affirm the ruling. The jury did have this for the Anderson County DSN Board and DDSN. They deliberated and came back with a defense verdict. And Judge Coggins gave us a judicious trial and went to a lot of trouble to make the right rulings on this. And we believe he did not err, and the lower court ruling should be affirmed.
Thank you very much.
No further questions. Thank you, ma'am.
Counsel, do you have any rebuttal?
Yes, Your Honor, I do. We keep hearing that Sandra was late on the scene. Every year, in addition to each incident, they had to inform the family. And I refer to the Zinnerman case, where the Supreme Court said, if a person who's incompetent gives consent, it's an invalid consent. And it could give rise to a 1983 claim. Your Honor, for years, they were giving him training on sexual responsibility, how to wear a condom, how to pick your partners. This person had the mentality of a preschooler. The mother and Angela were only consulted one time during his entire time at Anderson, when he eloped. Every year they had to be consulted on the plan, every incident they should have been informed of. As to Sandra appearing on the scene late, the record shows that they were taking him to Sandra's house on weekends. I can't remember, if it's 1 or 2 weekends a month for years prior to her finding out about the burned arms. Judge Wynn, you are exactly right about the SNAP benefits and what we weren't able to put in. For over a year after she took Johnny out, they kept his SNAP benefits. They didn't refund the overpayment that he had made for psych services. They were trying to set her up to fail so he would have to come back in and couldn't bring a lawsuit. They didn't tell her that she could get paid to take care of him or she could get some help at home with him. So, Your Honor, that goes to the retaliation issue. Your Honor, as to the slight care issue, Etheridge was not a case where you have a group home and a heightened duty of care. The Supreme Court established a heightened duty of care, of reasonable care, based on the applicable standards when there is a person in a group home. That case, the Etheridge case and the Young case that they cite, neither of those had that heightened duty of care. Your Honor, in 2017, in the Mims case, the South Carolina Court of Appeals affirmed the standard of reasonable care and the decision in the Madison case. Your Honor, as to the idea of experts, we identified those experts in October 2016 in our identification of experts. We also provided the report that Mr. Thomas had done, and they didn't raise the issue of us not having a expert report for our hybrid witnesses until the time of trial. So had they raised that, it could have been cured. The court did not use a standard this court has required that they use to determine whether a client should be excluded. Your Honor, we have shown that when he was released, he had 0 services. By the time of trial, they had limited him to 28 hours a week. We filed an appeal. It took 9 months to get a decision where we went up from 28 hours to 102 hours. Under Doe v. Kidd, Your Honor, we would respectfully ask for interim legal fees. These cases are expensive and these people don't have any money. I've been reviewing, hello?
Yes, we can hear you.
Okay, I've lost you, but if you're here, Your Honor, the court and other district courts have criticized us for engaging in a crusade. Your Honor, Matthew Perry, Thurgood Marshall, Spotswood Robinson, none of them brought the Sallie Mae Fleming case so that Sallie Mae would have a seat on the bus. They brought it as a private attorney general, just as Johnny Timpson brought this case as a private attorney general. And the fact that we're being criticized for a crusade, I kind of feel like Matthew Perry must have felt in front of George Bell Timmerman. We are not being given a level playing field, and we would ask that the court consider that Johnny Timmons brought this case in his important role as a private attorney general. And Your Honor, let me say just one quick thing. I can't see the timer anymore.
You're over time, but finish your thought.
Okay. As to the 1-year statute, Judge Agee, you were on the King Davis Grant case, or Grant Davis, and in that case that they rely on, the plaintiff acknowledged wrongly that there was a 1-year statute of limitations. He was claimed to be legally blind. He was a sex offender, and there were a number of reasons why the Fourth Circuit affirmed that case. So we would ask that the court consider the importance of clearly establishing the 3-year statute of limitations for the ADA.
Thank you very much for your argument, counsel. We're sorry we can't come down and shake hands with you, but we look forward to a day when we can do that. Now, I'd like to ask the clerk to adjourn court for the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.